right, I had another one. Morning. I didn't see Richard. Do we know if we have that juror?
He's here.
He's here?
Yes.
Excellent.
I'm going to give this back to you just so I'll take it back later. I had you logged in already because I had to look at the case.
Okay. witness and get feedback, and then we'll. You're here, right?
Yes.
Judge, after Ms. Orduno testifies, I believe we'll have you read the stipulations. The story is that you want the stipulations read before or after Mr. Navarro?
All right, let me find my stipulation instruction, and you have a stipulation.
So the fingerprint one and the DNA one.
All right, let me find. I've got the stipulation instruction. All right, Mr. Grant, are we on track to get started with the state's witnesses?
Yes, sir. Thank you. I was able to speak to our first witness. He does anticipate parking at 9:45.
Okay.
And so I said, keep me posted with your
I'll have you approach once they're finished with their witnesses.
excellent.
Is the state ready?
Yes, we are.
All right. Let's get the jury.
Yep. That's what
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning and welcome back. It's nice to see all of you all today after the day off. I thought about starting in the back row and letting each of you tell us what you did on your day off, but I'm not going to do that. Let me simply ask first whether anyone was exposed to anything about this case between the time you left the courtroom yesterday and the time you returned today, by show of hands. All right, let the record reflect there are no hands. Again, thank you all very much. We are now going to turn to the state and ask them to please call their next witness.
State calls Carol Orduno.
Carol Orduno. Ms. Orduno, good morning and welcome.
Good morning.
If you'll come forward to be sworn, wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat in the chair, make yourself comfortable. The microphone in front of you is adjustable. You ready? You may proceed.
Please state your full name for the record.
Carol E. Orduno.
Ms. Orduno, what do you do for a living?
I'm a driver.
What do you drive?
I drive for a landscaping company, delivering plant material to the job site.
Back in 2009, where did you live?
Ruskin.
And what did you do at that time?
I really wasn't working, doing stuff here and there.
At some point in 2009, did you know or come to know a person named Michael Keetley?
Yes, ma'am.
And were you going to work for him?
Yes, ma'am.
Can you tell us about that? What were you going to do?
He was showing me the route to do the ice cream truck.
Did you actually go in his ice cream truck with him or his ice cream van?
Yeah.
And how long were you doing that? Were you training with him to become an ice cream driver?
It was on and off, only briefly.
Was it more than a month or so, or was it less than that?
Yeah, maybe a month.
And during the course of working with him, had you actually been in his purple ice cream van?
Yeah.
When you were in that van, did you ever see him or know that he had a firearm in the van?
Yes, ma'am.
What type of gun was it? Do you remember?
That I wouldn't remember, but he showed he just wanted me to feel safe, which I did.
Was it a handgun or was it a rifle?
It was a handgun.
And where was that kept while you were in the van with the person you knew as Michael Keetley?
He had a little box on the back, where away from the window from the children.
And the person that you trained with on that van, do you see him here in court?
Yes, ma'am.
Can you please point him out and describe what he's wearing?
Yes, ma'am. He's over there with a brown sweater on.
Your Honor, may the record reflect she's identified the defendant? Ma'am, at some point, did you try to have your son work for the defendant?
My son was asking me about it, and I told him I'd ask him, because my son didn't have a driver's license at the time. So,
Back in 2010, how old was your son? I'm sorry to play math. Was he in his 20s or younger?
he was younger.
Younger than that. And what was the name of the son who you were trying to see if he could get a job with Mr. Keetley? Christopher. Okay. And at some point, do you remember, just for reference of time, do you remember a shooting that occurred on Ocean Mist in November on Thanksgiving of 2010?
I seen it on the news.
Now, I want to talk about the time period before then. Was there a time before then that you had seen Michael Keetley?
Yes.
Can you tell us about that? Where did that occur?
He came to my house. I found out he got shot doing his route, and he came over to see me after he got better, was able to walk. And he was asking for my son, and he wasn't there.
Okay, I'm going to stop you a little bit. So you were at your house, is that correct?
Yes.
And how did he get to your house?
He had a white truck.
And was he driving the truck, or was there anyone with him at the time?
No, he drove.
And this time that we're talking about in relation to the shootings that occurred on Thanksgiving of 2010, do you remember approximately when, in reference to that occurred? How much before the Thanksgiving Day shootings?
I'm not going to remember that.
Would you know if it was more than a month from that?
Whenever he got out of the hospital. That's all I know.
Sometime after he got out of the hospital.
Yeah.
But he was driving at the time, is that correct?
Yes, ma'am.
And he was in the truck?
Mm-hmm.
Now I want to ask you about the conversation that you had with him. What specifically, why was he looking for your son?
He wanted to know if he knew this guy named Creeper. He said that he heard he was bragging about shooting him.
And did he tell you the location where he thought Creeper lived?
Yeah, but I told him I didn't know nothing.
Okay, and do you remember what the street was?
Maybe Ocean Mist.
Okay. And what you said your son was not at home at the time, is that correct?
Correct. He was in Orlando.
And was that the extent of the conversation that you had with the defendant?
Yes, I told him that as soon as my son gets home, I'd ask him and I'd let him know, and he said okay, and he went on his way.
And sometime after the shootings that occurred over Thanksgiving of 2010, did you give an interview with law enforcement concerning that conversation?
Yes.
Your Honor, may I have one moment?
Yes.
Your Honor, we pass the witness.
Cross-examination.
Yes, sir. Good morning, Ms. Orduno.
Good morning.
So I have a few questions for you. First of all, there was a time that you said you were driving or working on the ice cream truck with Mr. Keetley, right?
Correct.
You referenced a firearm that
Correct.
he kept for safety
Correct.
purposes, right? You remember that being a revolver, don't you?
It's been so long now, I don't remember. I know it was a gun.
Was there a time that you did remember?
I'm sure there was.
If I showed you some prior testimony and had you read it to yourself, do you think that may refresh your memory?
Possibly.
All right. Your Honor, may I approach the witness?
You may.
I'm referring to prior testimony in February of 2020 that you gave, all right? And I'm going to refer court and counsel to page 1735. And I'm going to ask you to read to yourself. And you can start, if you'd like, on line 6 and read to line 14. Okay? Read to yourself, look at me, give me signal when you're done. All right, you're looking at me, so let me take my computer with the transcript back. Is your memory refreshed?
Not really.
Okay. All right. As you sit here today, it could have been a revolver, you just don't recall?
Could have been a 9mm. I know it was a handgun. That's all
Sure.
I know.
Fair enough. Let me ask you about this conversation that Mr. Keetley had with you in reference to Creeper.
Mm-hmm.
He asked about the name Creeper.
Mm-hmm.
And apparently, according to him, Creeper was the one who had shot him and was bragging about it.
Correct.
That's
what
what
he
you
told me.
recall. Now, we first can agree that this was a quick conversation you had, not a long conversation, right?
Correct.
And he drove up in his white pickup or off-white pickup truck, right?
Correct.
And I don't even think he approached you at all. He just talked to you very quickly at that time, right?
Yeah, he got out of the truck because I came out when I saw him.
And this was sometime after he got out of the hospital.
Correct.
You were aware, or had heard, rather, that he had been robbed and shot.
Correct.
Of course, you're not an eyewitness and know nothing about it, first-hand knowledge, but you were aware of that.
Yeah.
And sometime right after he got out of the hospital is when he had this conversation with you.
Correct.
Did he ever mention the name Magic
Not to my recollection.
or Spider?
Spider sounds familiar.
All right. Did he mention Juan Gatron?
No.
Okay, Sergio Gatron. Any name, the only name that you recall is this name of Creeper.
Correct.
Okay, that's the only one you recall for certain. Yes? Now, I'm going to show you an exhibit that's in evidence. You had received this text, right?
Correct.
Okay. referring to the shootings that occurred on Thanksgiving of 2010. Obvious question, you're not a witness, you know nothing about that firsthand.
Correct.
But you'd heard about it.
Yes, I did.
It was on the news. And you got this text.
Yes, sir.
And you do not know who you got this text from.
Yes, the detectives gave me. They asked me who sent it to me, and they drove me and I showed them the house where that lady lived.
All right.
I can't remember her name, but
So you did show them where
Yes.
they got it.
They-
And you got this text very close in time to these shootings. Right? And that's a yes. I'm sorry, we have to get your yes
Yes.
for the record. And you would also agree with me that it was very clear this text was going throughout the Ruskin community.
yes.
I have no further questions.
Redirect.
No redirect.
Will this witness be released and excused by the state?
Yes, Your Honor.
And defense? Or subject to recall?
Okay. Subject to recall.
All right, ma'am, you may step down. There's no reason to remain outside, but you are technically subject to recall. They'll call you and let you know if you have to come back. Thank you. I'll ask the state to please call your next witness.
The state will call Ricky Navarro.
Ricky-
And then, actually, before we do that, can you approach with the
You may.
stipulations?
Yes. I've read you the instruction before, but because I have two additional stipulations I'm going to read to you at this time, I'm going to go ahead and read the stipulation instruction prior to the stipulations. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are, first I'm going to read stipulation regarding fingerprints. The state of Florida and the defendant Michael Keetley hereby stipulate or agree that the following facts are true and correct. It is hereby stipulated by and between the state of Florida and the defendant Michael Keetley that Florida law enforcement fingerprint examiner Kaylee Adams examined the 10 .45 caliber spent shell casings from the Ocean Mist shooting scene and did not find any fingerprints suitable for comparison on any of the casings. We hereby certify the foregoing stipulation is made in good faith and for the reasons herein alleged, dated this 7th day of March 2023, and it is signed by the defendant Michael Keetley, Richard Escobar, attorney for defendant, and Michelle Doherty, assistant state attorney. And as with all other stipulations, I give them to the clerk, and then they will go back into the jury room with you. You will have them when you are deliberating. The second stipulation is titled Stipulation to DNA Results and reads as follows. The state of Florida and the defendant Michael Keetley hereby stipulate or agree that the following facts are true and correct. The Hillsborough County Sheriff's Office obtained a DNA saliva sample from victims Gonzalo Guevara, Richard Cantu, Daniel Beltran, and Ramon Galan. DNA samples from victims Sergio Guitron and Juan Guitron were obtained from the Hillsborough County Medical Examiner's Office. DNA testing was conducted by the Florida Department of Law Enforcement analyst Beth Orderman on several items of evidence with the following results. Number 1, DNA identified on 2 spent .45 caliber Winchester casings collected from the homicide scene matched the DNA profile of Ramon Galan. Number 2, DNA identified on 1 spent .45 caliber S&B casing collected from the homicide scene matched the DNA profile of Juan Guitron. Number 3, DNA identified on 2 spent .45 caliber Winchester casings collected from the homicide scene matched the DNA profile of Gonzalo Guevara. Number 4, a partial DNA profile obtained from one spent .45 caliber Winchester casing collected at the scene was insufficient to identify any person as the source of the DNA. Sergio Guitron, Juan Guitron, Daniel Beltran, Gonzalo Guevara, Richard Cantu, and Michael Keetley are excluded as the source of this partial profile. Ramon Galan could not be excluded as the source of this partial DNA profile. Number 5, no DNA results could be obtained from 4 spent .45 caliber Winchester casings found at the scene of the homicide. Number 6, a partial DNA profile obtained from swabs taken from the steering wheel of the Chevrolet van driven by Michael Keetley on November 27, 2010, matched Mr. Keetley's DNA profile. Number 7, the Chevrolet van's driver's side floor mat, driver's side front seat bottom, and passenger side front seat adjustment lever, and a green towel collected from the van failed to give chemical indications for the presence of blood. We hereby certify that the foregoing stipulations is made in good faith and for the reasons herein alleged, dated this 7th day of March 2023. It is signed by Defendant Michael Keetley, Richard Escobar, attorney for defendant, and Michelle Doherty, assistant state attorney. And I will hand all of these stipulations to the clerk. And I'll ask the state to please call your next witness.
Now we'll call Ricky Navarro.
Ricky Navarro. Mr. Navarro, good morning and welcome.
Thank you, Your Honor. Good morning.
Watch your step. If you'll face me and raise your right hand, please. Do you swear affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair. Go ahead, have a seat, make yourself comfortable. If you've got stuff that you need to unpack, you go right ahead. You let me know when you're ready, and I'll let the attorneys ask you some questions. All right, Ms. Johnson, you may proceed.
Yes, Your Honor. Can you please tell the jury your first and last name and spell your last name, please?
My name is Ricky Navarro, Navarro.
And how are you currently employed?
I'm a forensic print analyst for the Hillsborough County Sheriff's Office.
And how long have you been employed with the Hillsborough County Sheriff's Office?
November of this year will be 22 years.
And your current assignment is as a forensic print analyst?
Yes, ma'am.
Okay. And what are your duties as a forensic print analyst?
My duties as a forensic print analyst is to examine latent prints submitted by deputies, crime scene, to determine if those latent prints are of value for comparison purposes. Would I be able to eliminate or identify the individual that left those latent fingerprints? Then I would make if prints are of value, I would make a comparison to any known fingerprints requested or any fingerprints that may have possibly left those prints.
Do you have any prior employment prior to the Hillsborough County Sheriff's Office?
Yes, ma'am.
And can you please tell what your prior employment is to the jury?
Yes, I was hired by the FBI and ordered to report to Washington, D.C. September of 1969. At orientation, where you fill out all your paperwork and get your job assignment, I was assigned to be trained as a fingerprint examiner. After orientation, I attended an 11-week course in the science of fingerprints and 2 years on the job training in fingerprint classification and identification. I worked for the FBI for approximately 7.5 years. The end of February of 1977, I resigned from the FBI, and on March 1st of 1977, I entered on duty with the North Carolina State Bureau of Investigation, Raleigh, North Carolina, fingerprint section. In the fingerprint section, I worked several different units. Later, I was sworn in as a special agent, attended a 26-week SBI academy. After I got out of the academy, I was reassigned to the latent evidence section. In the latent evidence section, I attended a 1-week course in latent fingerprint work taught by the North Carolina State Bureau of Investigation. I attended a 1-week course in advanced latent fingerprint work taught by the FBI in Fayetteville, North Carolina. I attended a 3-week course in administrative advanced latent fingerprint work taught by the FBI in Quantico, Virginia. During my employment with North Carolina, I was later sent to the North Carolina Justice Academy Instructor Training Course for 3 weeks. I completed that course, became the training officer for the North Carolina State Bureau of Investigation Latent Evidence Section, with the responsibility of training all new latent print examiners and law enforcement officers throughout the state of North Carolina when requested. I worked for the North Carolina State Bureau of Investigation for approximately 24 and a half years. I retired November 1, 2001, and entered on duty with the Hillsborough County Sheriff's Office November 5, 2001.
And part of your position with the Hillsborough County Sheriff's Office, are you required or do you participate in continuing education classes?
Yes, ma'am. When I hired in with the Hillsborough County Sheriff's Office, they asked me if I would mind becoming certified by the International Association of Identification Latent Fingerprint Examiners. And I told them I didn't have a problem with it, so after a couple of years with the Sheriff's Office, they sent me to the IAI certification testing association for identification, and have been certified by them ever since. Every 5 years I have to take a recertification test, and you must pass that test with 100% accuracy, which I took my last test approximately maybe 3 years ago.
And do you utilize any equipment to conduct your course of business?
Yes. In the section, of course, you have the 4-power magnifier that you will place on top of the latent print and the inked impression together to compare the similarities or dissimilarities in the latent print and the known inked impression. You also have now computers that will allow you to scan in the image and look at the image on the screen of the computer. So there's been different pieces of equipment made available to us over the years.
Have you previously had an opportunity in your course of employment to compare latent fingerprints obtained from a scene to someone's known fingerprints?
Yes, ma'am.
How many times have you done that?
I've been doing this, come September will be 54 years. Many millions of latent lifts to known sets of inked impressions over that period of time.
Have you testified previously in Florida courts and other courts related to your work in this area?
Yes, ma'am.
What other courts other than within the state of Florida have you testified?
State and federal courts in Virginia, North Carolina, Florida, in excess of 450 times.
And has a court ever refused to allow you to testify regarding your work in this area?
No, ma'am.
I'd ask if the defense has any questions in this limited area.
Any questions?
No questions, Your Honor.
All right, you may proceed.
We've said the term latent fingerprint. Can you explain to the jury what a latent fingerprint is?
Yes, a latent fingerprint is the unintentional reproduction of the friction ridge detail on the palmar surfaces of the hand. When that hand comes in contact with an object, you transfer substances from the hand to the object that is being handled. These latent prints are invisible to the naked eye, but they can be made visible by the use of commercially prepared fingerprint powders, and/or chemicals.
Can you explain what a known fingerprint is?
A known fingerprint is the intentional reproduction of the friction ridge detail on the palmar surfaces of the hand. This is done by taking the individual and rolling their finger in what is called printer's ink. It's black in color, and then transferring that onto what we call a fingerprint card. Then you have a permanent recording of the friction ridge detail on the palmar surfaces of the hand, which would be the known fingerprints.
Are there distinguishing characteristics of each person's fingerprint?
Yes, each person first has fingerprint pattern types in their fingers. There's 3 basic types. There's arches, loops, and whorls. An arch is a pattern where the ridge detail comes in on one side of the finger, goes toward the center, makes a slight rise, and then exits the opposite side of the finger from which it enters. A loop is a pattern that can come in from either the left or the right. The ridges come into the finger, they recurve, and they exit the same side of the finger from which they enter. A whorl would be like a target where the ridges are going into a circular motion. So those are the 3 basic patterns of fingerprints. Inside those fingerprints, you have unique identifiable characteristics. There's 5 of those. There's a dot. That's a ridge that formed but never went anywhere, just formed into a dot. You have a short ridge. That's a ridge that formed, but you see both ends of it, where it stopped and started. Then you have a ending ridge. You don't see where it started, but you see where it abruptly stops. Then you have a bifurcation. That is a ridge that runs for a distance, splits into 2 ridges, and a short distance later comes back into 1 ridge again. Bifurcation, the island is the ridge that bifurcates, goes into 2 ridges, comes back into 1 ridge. So those are the 5 basic characteristics in the fingerprint. The points of unique identifiable characteristic are the positioning of those unique identifiable characteristics. In other words, if I have a dot, 3 solid ridges, and then a bifurcation that opens in an upward position, the latent print, the inked impression, I must have that same unique identifiable characteristic in the same relationship.
Can you explain how someone leaves behind a fingerprint?
Yes. When in the fingers you have sweat pores. There's approximately 2,700 sweat pores per square inch, constantly secreting body fluids. Also, when the hands come in contact with such as the forehead, around the eyes, those are oily areas of the body, they deposit it onto the fingers. When the person touches an object, they transfer those substances onto the object that is being touched. That is a latent print. Now, if that latent print is on a non-porous item, that is an item that will not absorb the print, then you must go after that print with several different type of methods, fingerprint powder being one of them. If it is an item that the print will absorb into the item, such as paper, then you can apply a chemical such as ninhydrin that will go into the paper, react to the amino acids in the fingerprint, and cause that fingerprint to come up purple in color.
Is it possible for someone to touch something and not leave behind a fingerprint?
Yes, there are several ways of touching something and not leaving a fingerprint. First of all, the condition of the item that's being touched will affect whether you leave a fingerprint. If a person puts something over their hand, such as gloves or a sock, you can touch something and not leave an identifiable print. The conditions of the hand at the time you touch something, you may or may not leave a fingerprint. For example, if I were to go into the bathroom, wash my hands really well, dry them, come back in, and I haven't had time to secrete those amino acids, sweat out of my fingers, I can actually touch something and either leave a very light print or not leave a print at all. Also, whenever you touch something, if you touch it and you come back and touch it again, you put print on top of print. You'll leave a print, but you're not going to leave identifiable print sometimes.
Can you explain that a little bit further? When you were just talking about how you touch something and you touch it again and it's print over print, that it may not be something that you don't leave behind an identifiable print. What do you mean by that?
Take a Coke can. The Coke can's got a opening at one end of it where you're going to have to drink out of it. You can only hold that Coke can in one position. You're not going to hold it. You're going to have usually your thumb where the opening's at. Your fingers are going to be on the backside, whether it's a right hand or left hand. You take a drink out of the Coke, you set it down. Later on, you pick up the Coke. You're going to have to pick it up basically in the same place you picked it up the first time. So if you pick it up 2 times or 3 times, you're placing those prints on top of each other. And you can't separate the first print from the last print that was placed there. So what you have is unidentifiable fingerprints, because now you've taken a print. The first touch may have left a good print, but continued touching on top of the prints rendered those prints of no value.
How do you go about comparing latent fingerprints to someone's known fingerprints?
First thing you do is determine whether the latent print's of value for identification purposes. Then you try to determine whether it's a fingerprint, second or third joint of a fingerprint, or a palm print. If it's a palm print, you try to determine what area of the palm it is. Now let's say it's a fingerprint that you're going to make a comparison of. First you look at the pattern type in the latent lift, if you've got the pattern type, and you compare it to the pattern types of the fingerprint card. Let's say that a person has a loop type pattern. The ridge is coming in on one side, recurving, going out the same direction as what they came in. And you start looking at the fingerprint card, and the fingerprint card, the finger has an arch in it. You know the arch, the loop couldn't have made the arch. It has whorl in the fingerprint card. You know that loop couldn't have made the whorl type pattern. Then when you come into a fingerprint that's got the same loop type pattern, say it's a left slope loop, ridges are coming in from the left, recurving, going out, and you have a right slope loop on that fingerprint card, couldn't have made the left slope loop. Now you come to a fingerprint on that card that has a left slope loop, then you have the same pattern type. Then you look at the ridge flow. Ridge flows could be different on each different type of loop type pattern. If the ridge flow is consistent, then you move on to the next step, and then you start looking for the unique identifiable characteristics, the dots, short ridges, ending ridges, bifurcation, islands. You start looking at those unique identifiable characteristics in the latent and the inked impression. If you don't have the same unique identifiable characteristics and same relationship to each other, you eliminate that finger. If you have the same unique identifiable characteristics in the latent and the inked impression, then you will come to an opinion that that latent print was produced by that finger.
Are fingerprints unique or specific to each individual?
Yes, they are. The fingerprints are unique to each and every individual. It's not been found that 2 separate individuals have the same fingerprint, and it's never been found that one individual has the same fingerprint on 2 different fingers. Each finger is unique to that individual.
Does that include identical twins, that they don't share the same fingerprints?
Even identical twins. When I worked for the FBI, the files had quite a few identical twins in it, and even though their fingerprints are similar, the unique identifiable characteristics were unique to each individual.
What is the difference between an identifiable print and an unidentifiable print?
An identifiable print means that I can either identify or eliminate the individual that left that print. Unidentifiable print means I cannot tell you who left that print or who did not leave that print. The quality of the print, the overlapping, the smudging, anything that could have happened to it is rendering that print that I can't say this person left it or didn't leave it.
If you say a print is of no value, is that the same thing as saying that it's an unidentifiable print?
That is correct. Unidentifiable is just another term used for unidentifiable, no value.
Is it possible to have a print that is of value, but you cannot identify the person?
If the prints of value and the quality of the known prints are of good value, good quality, I would be able to identify that individual or eliminate that individual.
Okay. Were you asked specifically in your course of business with the Hillsborough County Sheriff's Office to assist law enforcement regarding a case involving a defendant by the name of Michael Keetley?
Yes, ma'am.
And did you receive latent prints recovered from various crime scenes in this case?
Yes, ma'am.
And did you receive those latent fingerprints from crime scene investigators, such as crime scene investigator Patel, crime scene investigator Brando, and Ramirez and Durr?
Yes, ma'am.
Did you receive latent prints from the crime scene specifically? Were you asked to examine ammunition and driver's licenses?
I don't specifically remember ammunition or driver's license that I was to look at in this case.
Were there numerous latent prints sent to you to conduct comparisons of?
I received in the latent evidence section I received 9 envelopes. Those envelopes either contained latent lifts or they were envelopes where anytime something's processed with chemical in the lab, you can't lift the image off that item, so you have to photograph it. And the photographs are put into a computer system that I can go into and retrieve the image. I cannot alter that image that's in the computer. I can retrieve it and I can process that image. And I received envelopes where the photographs were in the computer system and some latent lifts.
Within those 9 envelopes, are there multiple latents within the envelopes, or is there one latent within each envelope?
In the envelopes I had 5 envelopes that contained latent lift cards. I had 3 envelopes that contained photographs, and I had 1 latent lift that was marked as a shoe card, indicating that there was a shoe impression.
What's the difference between a latent lift card and a photograph?
The latent lift card is a process where the individual applied fingerprint powder to the surface, noted that there was some ridge detail on that surface. They don't take into consideration is that print of value or no value for comparison purposes. They just find the ridge detail. Their job is to lift that ridge detail and place it onto a lift card. That makes a permanent record of the impression as they saw it on the item. It's my job to determine if there's anything of value in it. So a lift card is something that's been powder processed, piece of tape put on it, lifted off that item, put it onto a lift card, and put into the envelope. Photographs are images that could not be lifted. They were processed chemically, and so therefore they photographed them. When I receive the envelope, it's empty. I go into the computer and I retrieve the images from the computer.
The envelopes that you have, is it fair to say that those are envelopes that either the prints were of no value to make a comparison, or you were not able to identify anybody to those prints?
Both. They were either of no value or I didn't identify anybody to those prints.
And if you don't have the person's known fingerprints, if it was of value but you didn't have the person's known fingerprints, you're not able to make a comparison. Is that correct?
That is correct. If I don't have the known prints of the person to compare to it, then that print will go unidentified.
Did you have an occasion to take the known fingerprints of Michael Keetley?
Yes, ma'am.
Put to witness, Judge.
Absolutely.
Mr. Navarro, I'm showing you what's been pre-marked as State's Exhibit 116 for identification purposes. Have you previously viewed this prior to appearing here today?
Yes, ma'am.
And is it in the same or substantially the same condition as it was on the date that you collected it from the defendant, Michael Keetley?
It's in the same condition.
State offers an evidence, State's Exhibit 116 at this time.
Any objection?
No objection.
116 will be admitted.
Do you see Michael Keetley here in the courtroom today, the individual that you collected these fingerprints from?
Yes, ma'am.
Can you please point to him and describe an article of clothing that he's wearing?
Light-colored jacket, the next to the end on the right-hand side.
Please let the record reflect he has identified the defendant.
The record shall so reflect.
Permission to publish, Judge?
You may publish.
Mr. Navarro, can you tell us, explain to us what we're looking at here and how you went about collecting these fingerprints of Michael Keetley?
Yes, I was requested by the State Attorney's Office to obtain the known inked impressions of Michael Keetley. I believe I came to the courthouse on June, the date would be July the 16th. Came to the courthouse, met with Mr. Keetley, and I took his fingerprints and palm prints at that time.
And are these those prints that you collected?
Yes, ma'am.
First witness, Your Honor.
You may.
Mr. Navarro, I'm showing you what's been pre-marked as State's Exhibit 116A, as well as 116B for identification purposes. Were you shown these prior to arriving here today?
Yes, ma'am.
And are they in the same or substantially the same condition as the date that you worked on them?
Yes, ma'am.
State offers an evidence, State's Exhibit 116A and 116B.
Any objection?
No objection.
They'll be admitted.
Permission to publish?
You may publish.
I'm going to start, Mr. Navarro, with 116A. And this is a photograph, is that correct?
Yes, ma'am.
A scanned photograph?
Yes, ma'am.
can you tell us how this photograph came to be and what you did with this photograph?
As I stated earlier, I received empty envelopes indicating that there was some images in the computer to be viewed and examined to determine if there was any latent prints of value for identification purposes. I did retrieve the images from the computer, and I processed those images to show the one latent fingerprint of value for identification purposes, which means that if I had a known set of inked impressions, I would be able to identify that one latent fingerprint of value on State's Exhibit 116A.
Yes. Did you make a comparison regarding State's Exhibit 116A to the defendant's known fingerprints that you collected, State's Exhibit 116?
Yes, ma'am, I did.
And what opinion did you come to after making that comparison?
After making the examination and the comparison of 116A to 116, I noted that the one latent fingerprint of value was made by the left thumbprint of Michael Keetley on State's Exhibit number 116.
Now, when you received this for comparison purposes, I'm going to show you State's Exhibit 115. Do you ever actually receive State's Exhibit 116 to make any kind of comparison purposes, or are you making your comparison purposes from the lift that was already collected by crime scene investigator Brando?
I never saw that book until yesterday, so the examination I did was based on the photograph in State's Exhibit 116A.
And your job is to make the comparison, not to collect the latent print. Is that correct?
That is correct.
Now publishing State's Exhibit 116B, which is another photograph a latent print that had been collected by crime scene investigator Brando. Did you collect this photograph from the computer the same way that you described in 116A?
Yes, ma'am.
And did you make a comparison to the defendant's known fingerprints on 116B?
Yes, ma'am.
And what was your opinion?
It was my opinion that the one latent fingerprint of value in State's Exhibit 116B was made by the left index finger on State's Exhibit number 116 of Michael Keetley.
Mr. Navarro, I'm going to show you what's already been introduced into evidence as State's Exhibit 116C. May I approach, Your Honor? Mr. Navarro, do you recognize this photograph as well, 116C?
Yes, ma'am, I do.
And this was a latent print collected by crime scene investigator Durr from a racetrack cup located within a van. Did you collect, publishing 116C, did you collect this photograph the same way you described as collecting 116A and 116C? I'm sorry, 116A and 116B.
116C is a lift of a impression that was on identified to me as a racetrack 32-ounce cup. That was submitted as it appears on the screen as a latent lift. I did not have to go into the computer to retrieve it. I made the comparison of the one latent fingerprint of value on that cup to Mr. Keetley.
And what was the print left behind by the defendant on this racetrack cup?
The left thumbprint on State's Exhibit number 116C was made by the left thumbprint of Mr. Keetley on State's Exhibit number 116.
Publishing briefly 116 again. When you're talking about looking at ridges and loops and whorls, is this what you're describing that we're seeing in the left thumbprint and the left index finger of the known prints of Michael Keetley? Is that what you are looking for, the patterns within these known prints to the patterns on the latent fingerprints?
Correct. In State's Exhibit number 116, the left thumbprint is a arch type pattern, which means the ridges are entering on one side of the finger, making a slight rise in the center and exiting the opposite side from which they enter. The State's Exhibit 116 has the same pattern type that I had in the two thumbprints that I identified. It also had the same unique identifiable characteristics in those two left thumbprints as to the left thumbprint in State's Exhibit 116.
The other latent print cards that you had, that you brought with you today, and those 9 envelopes that we discussed, did you compare those to the known prints of Michael Keetley?
Yes, ma'am, I did. Those that are of value.
And were any of those able to be identified to Michael Keetley?
No, ma'am.
Were you also asked to compare those prints to other known individuals? Were you given other names and other known individuals' fingerprints to make comparisons?
Yes, ma'am.
Did you make comparisons of the latent prints in this case to known prints of Alani Tyndale?
Yes, ma'am, I did.
Did you identify any prints that were of value were any of those identified to Alani Tyndale?
No, they were not.
Was he eliminated as leaving behind any of the latent prints you were requested to compare?
Those fingerprints of value. Those that are of no value, I can't eliminate or identify.
Were you given known fingerprints of a David Beckwith?
Yes, ma'am.
And what were your findings with regards to the latent prints that you made comparisons of?
He did not leave any of the fingerprints of value for identification purposes.
And were you provided known fingerprints of a Wesley Smith?
Yes, ma'am.
And what was your opinion regarding your comparison of the latent prints to the known prints of Wesley Smith?
He did not leave any of the prints that are of value for identification purposes.
Your Honor, may I have a moment? The state would pass the witness at this time, Judge.
Good morning, Mr. Navarro.
Good morning.
I wanted to simplify your process just to make sure we're tracking your exact role because we've gone over a lot of information.
Yes, ma'am.
So essentially, and correct me if I'm wrong, again, oversimplify, you receive prints from crime scene investigators that lift at various locations at various times, correct?
That is correct.
You then review these prints to see which are of good value or also of comparable value, correct?
Yeah, correct.
And then from there, when you have the prints of comparable or good value, you are given known prints. And these known prints are given to you by law enforcement or the state attorney's office.
Correct.
And for example, the known prints that you were just shown by the prosecutor that you rolled of Mr. Michael Keetley, you rolled both hands, correct?
Yes, ma'am.
So you received, I believe you said 9 envelopes.
There was 9. One was marked as a shoe print.
And that one was not something that you did anything with, correct?
No.
It wasn't anything you were able to compare, I guess is a better way to put it.
I never made any kind of examination of it.
And within those, I guess we could call it 8 envelopes in which you reviewed to make some sort of a comparison. There were these all good value, or did you have to make that determination?
I would have to determine each envelope. I would go and look at each one of the latent lifts in each envelope to determine whether it was of value for comparison purposes or not of value.
And so I want to start with the set of envelopes you received from crime scene investigator Patel and Ramirez of the crime scene. Because when you receive these envelopes, you get the crime scene investigator who lifted the print, the location, a general idea of the location in which these prints were collected, and a date. Is that correct? A date
yes.
that they were lifted.
Yes.
And the ones from crime scene investigator Patel and crime scene investigator Ramirez were lifted from an ocean mist court on November 25th, 2010.
That's what it says on the envelope.
And in using your skills to make a comparison and an identification, none of those prints from that crime scene on November 25th, 2010 were identified as belonging to Mr. Michael Keetley.
That is correct.
You mentioned the difference between unidentifiable and unidentified. There is a difference between those two, correct?
Unidentifiable is a print that's no value. Unidentified means that it's of value, but I did not identify it to anyone.
Meaning that the prints you were given to compare did not match, as far as your opinion is concerned, as belonging to those people you were comparing it to. Correct?
Those of value did not belong.
Those of value. So things can be unidentified but not unidentifiable, correct?
Yes, ma'am.
Now I want to move to the 3 specific prints you were able to identify. First with the ones that were identified by crime scene investigator Durr. Those were, and if you need to check your envelope, please, because I don't know if I remember correctly. I think it's November 27th of 2010, collected by crime scene investigator Durr. Or 28th.
I've got November 30th.
Oh, I was wrong. November 30th. So a separate day and a separate location than the ones we previously discussed, correct?
Yes, ma'am, of the prints that were lifted.
And the prints that were lifted came from a vehicle, and specifically a racetrack cup, like a styrofoam soda cup.
Identified as racetrack cups, different items that are indicated on the back.
And 2 prints came from that as of value, of good value, correct?
2 prints
2 latent prints from that cup.
from that cup.
Yes.
Only had remember 1 latent print of value from that cup.
You can review your notes if needed. I know that there was one that was identified. And if it would help, I can pull up your report or your deposition.
Yes, there was another latent print, which it was a loop type pattern.
So that one identifiable but unidentified.
Correct.
And the one in which you were able to identify was the one that belonged to Mr. Keetley, correct?
Correct.
And that was from the left hand. I believe you said left thumbprint, was it?
Yes, ma'am.
Now I want to move to another envelope that was sent to you as being lifted by a crime scene investigator, Brando. Can you please let the members of the jury know what date that was collected?
I have one envelope that was from Brando. It is a photograph. Brando processed something and had to photograph it to retrieve the image.
And was this one you were able to identify that the prosecutor just showed you before I started speaking to you?
Yes, ma'am.
And what was the date and location?
The date on the envelope is April the 15th, 2013.
And does it say the date that it was, is that the same date that it was lifted, or does it give you a location as well?
That's something Brando would have to answer. I only know what says on the envelope.
Understood. And that was what appeared to be coming from a composition notebook, correct?
Yes, ma'am.
And you said that there was one or two in that envelope.
In this envelope, I have two photographic images in this envelope now. I had the other two that you have up there. In this envelope, there was also one additional latent fingerprint of value for identification purposes that I did not identify to any of the individuals.
And I just want to make sure that, again, we're tracking on the same thing. I have State Exhibit 116A. Is this one of them that you're mentioning?
Yes, ma'am.
In that envelope? And then I also have State Exhibit 116B. Is this the second one that you're referring to?
Yes, ma'am.
And these two, as previously testified to, you identified as belonging to Michael Keetley, correct?
Yes, ma'am.
Both coming from Mr. Keetley's left hand.
Yes, on the photographs, the left thumbprint and the left index finger.
I have no other questions. Thank you.
Mr. Navarro, your role is not as a crime scene investigator to collect evidence from an actual scene. Is that correct?
That is correct.
You get the items, the latent prints for comparison once they are lifted by a crime scene investigator and sent to you for comparison purposes?
That is correct. I don't see any of this stuff. I don't go to the crime scene until the crime scene people submit me the envelopes that I've testified to. That's all the knowledge I have on the case.
And you can't make comparisons until you have someone's known prints to compare them to?
The latent prints are entered into what is called the AFIS system, the Automated Fingerprint Identification System. There are 3 of those systems in Florida that we use. We have the local system, which means it searches fingerprints that are in the database for Hillsborough County. If it comes back as negative, you don't make a hit in Hillsborough County, then it goes to the state system, which is FDLE, and goes through their computer system. You may make a hit there. If you don't make a hit or a possible identification off of the state system, then it goes to the FBI, and it's searched through the FBI system, which is the entire United States. In this particular case, some of these latent lifts of value, or the latent lifts of value for identification purposes, were searched through all 3 systems, and no identification was made on any of them.
Thank you. Nothing further for this witness, Judge.
May this witness be released and excused by the state
Yes, Your Honor.
and the defense?
Yes, you may release. Thank you.
All right, Mr. Navarro, thank you. You may step down. You may be released and excused as a witness at this time. I'll ask the state to please call your next witness.
Judge, at this time, the state is going to introduce the redacted employment records, which is State's Exhibit 94 of the defendant, as well as the text message from the phone download, which are also redacted, State's Exhibit 207, into evidence.
Any objection?
As to the employee records, we went through them to redact any sensitive data, so what we've redacted we're good with. and I think you also said the text messages.
Yes.
We had that discussion yesterday in our downtime as well, so we agree.
And you've checked the redactions on the version that's being admitted?
I have, and more importantly, Ms. Khan has, because that's been one of her areas.
So that's
We're
ready
good.
to be admitted?
We're
Yes,
good.
Judge.
All right, they'll both be admitted.
And Judge, at this time, the state would rest.
All right. Let me have the attorney's approach briefly. Stretch break. We're going to turn to the defense. They're going out to make sure their first witness is there. So if you want to take a standing stretch break until we get the defense first witness on the stand. Actually, I'll do the same. I do intend to still give you your morning break after the witness. I've been told the first witness will not be that long, so then we will take our morning break. You ready, Mr. Grant?
We are.
All right, call your. Let the members of the jury get comfortable again. All right, they're all seated. Looks like someone needs a pen. We'll get a new pen or pad, and I will ask the defense to please call their first witness.
Yes, sir. Michael Keetley's first witness is James Kennedy.
Mr. Kennedy, good morning and welcome, sir. If you'll raise your right hand to be sworn as a witness, please. That's right there is perfect. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. If you'll follow the bailiff now to the ramp, please watch your step. Go ahead, have a seat in the witness chair. The microphone in front of you is adjustable.
Which one, this one?
That one, the one closest to you. All right, you may proceed, Mr. Grant.
Thank you, sir. Good morning. Will you please introduce yourself to the jury? Spell your last name for the court reporter.
My name is James Kennedy. Last name is Kennedy.
All right, Mr. Kennedy, I'm going to stand over here to kind of help make sure that the jury can see you.
Okay.
I'm going to talk loud to help you talk loud as well so that everybody can hear you.
Got it.
All right. First of all, let me ask, without giving me any specific address, where do you live?
Mulberry.
And that's in Polk County, I believe.
Correct.
So you came here today
Yep.
to give testimony in this case.
I did.
Let me first ask you, what do you do for a living?
I'm a chemical engineer.
How long have you been doing that?
2 years?
Let me turn your attention to November of 2010. All right? Have you given testimony on that time frame before?
Yes.
I want to ask you about a magazine called the Florida Gun Trader. Do you know that?
It's actually online. It's a website.
Sorry, e-zine, I should have said. What is the Florida Gun Trader?
It's where people can buy, sell, trade guns, ammo, accessories.
In November of 2010, did you purchase advertising or put a gun up for sale?
Put one up for sale. You can do it for free.
Okay, I didn't realize it was that. And you recall what type of firearm that is?
That I put up.
Yes, sir.
Ruger 1022.
And what is a Ruger 1022?
It's a starter rifle for kids or for young adults.
You say starter rifle for kids, young adults. Do you have an idea how much it weighs approximately?
3 pounds? Maybe?
And you were going to sell it.
Yes,
Did you get a buyer?
I did.
And do you remember the specific day in November that you sold this rifle?
No. It was mid-November.
And do you remember where well, let me ask you first, did this sale take place?
It did.
And do you remember where the sale took place?
Yes. Parking lot of Winn-Dixie.
Sorry, can you repeat
The
that?
parking lot of Winn-Dixie
In what area of town?
in Riverview.
Were you living in that area at the time, or were you living in Polk County?
No, I was living in that area.
Do you recall who you sold that starter rifle to?
Yep. Yes.
Who did you sell that starter rifle to?
Michael.
You just turned and said Michael. Are you referring to Michael Keetley?
I am.
Do you see Michael Keetley in court today?
Yep, I do.
I would assume so, since you looked in that
Yeah.
area. Will you please identify him?
He's the gentleman in the beige sweater.
The beige cardigan.
Cardigan.
There you go. May the record reflect that Mr. Keetley has been identified by James Kennedy.
Record shall so reflect.
So here's my question. In 2023, you're able to identify Michael Keetley. Did you somehow have a prior knowledge of or relationship with Michael Keetley?
Yeah, we went to high school together.
So this sale is going to take place in 2010, and I'm sorry I'm going to do it to you. About when did you go to high school with Mr. Keetley?
We graduated. I graduated in '88. I think he graduated also in '88.
Were you friends in high school?
We were acquaintances.
When you say acquaintances, hang out sometimes, talk sometimes?
No, not typically, but we were. I think we maybe had classes together. We were in-school friends, I guess you'd call it.
Gotcha. I'm not sure if I asked you the question or not what high school this was.
East Bay High School.
And East Bay, is that in the south?
That's in Riverview also.
Gotcha. Kind of close to that Gibson, Ruskin area, not too far.
Yeah, 10 or 15 miles.
As far as your meeting with Mr. Keetley on this date in mid-November of 2010, you indicated that a sale did take place.
Correct.
Do you recall the price?
I'd have to guess, but $150, $200, somewhere there.
How did the transaction take place?
Through Florida Gun Trader, you email back and forth, and then once we figured out that he wanted to purchase the gun, then we exchanged phone numbers and then text back and forth and made arrangements to meet, and then we met up at Winn-Dixie.
And did he pay you in cash,
Yes.
credit card? How did that work?
Cash.
Right. Is that unusual for a gun transaction to be done in cash
No.
in your experience?
It's more typical.
Right. You say more typical what?
Well, if you're buying something from a stranger, you don't know if that check's going to bounce.
Gotcha. You wanted to make sure that when you're getting 150 to 200 bucks, you're
Right.
actually getting your
Not just
currency.
paper, right.
All right. I think you've testified that you don't recall exactly when in 2010 this sale took place. Do you recall the time of day? Was it light out? Was it dark?
It would have been after work, so 6 o'clock, maybe 7 o'clock.
Did you have any issues with vision or
No.
obstruction?
No.
When you saw this, well, let me ask you this. When you're going to this Winn-Dixie, did you know at this point in time that it was Michael Keetley that you were going to meet?
No.
All right. So you didn't even know,
No.
have a name?
Right. Well, up to that point, it was just Mike and James.
Very
No
good.
last names.
So when you arrive at the parking lot and the person meets you, did you recognize him?
I did.
And how is it that you recognized him? Or what did you recognize him as?
His face.
Okay. Maybe we changed a little bit over
Little
time,
bit,
but
but,
you
yeah.
could still see high school Michael Keetley.
Correct.
Did you greet him?
I did.
Did you go to shake his hand?
I did.
All right. How did that go?
I had to shake with my other hand. I usually shake with my right hand.
Sure.
And I remember putting my hand out to shake his hand, and his.
Stop you there. You said, because I want to make sure the record is clear, you said you went to put out your right hand and you made a demonstration.
Correct.
So you actually stepped forward and extended your right hand.
Yes.
And what was the response?
That's when I noticed his right hand to shake mine didn't work like it should. So I switched hands.
Describe what you meant by that.
The best way to describe it is he looked like he had had a stroke. So half his body didn't quite work like the other half.
What about a limp or anything unusual about his walk or what we would call his
He did.
gait?
He had a limp.
Was it significant to you?
There was no doubt when you watched.
Okay.
So
So I think you said the right side of his body looked like it wasn't working or functioning properly.
correct.
And it was that obvious to you.
Yes.
Okay? Did you ask him about his physical condition, what had happened, whether it was a stroke or anything else?
No, I'm not one to pry, but and in conversation, it came up, I guess.
There is some idea out there that Mr. Keetley was a victim of a robbery and an attempted murder or shooting. You don't know anything about that firsthand.
No.
Had you heard anything about that?
Prior to Michael telling me,
Correct.
no.
Did you give him this starter firearm or starter rifle?
I sold it to him.
Right. Well, yes. Sorry, it's a poorly phrased question. Let me ask it to you this way: when you sell it to him, you get your cash. He's going to get the rifle, right? And this is a legal transaction, sure. And when you gave it to him, I want to know what he did, how he grabbed it. May I approach the witness?
You may.
I'm going to a little bit of a crude or weird example. I'm going to ask you to presume that this yardstick is the rifle.
Okay.
Guys, I'm going to ask you to stand up for me if you don't mind. And I'm going to be you, and I'd like for you, sure, that'll work. I'm going to be you as you're coming around, and I'm going to ask you to be Michael, okay? So when you're giving him the firearm, can you demonstrate? I'm going to have you turn just a little bit so the jury can see it. I'd like for you to show me how he handled that rifle.
It's been a long time.
Okay, if you don't remember, that's okay.
I don't remember if he grabbed it with his left hand and brought it over to his truck bed to look at it. I know he didn't do this.
All right. When you say didn't do this, you grab.
When you typically grab a rifle, you grab it with two hands, and you look, you look down the stove, you check out the rifle that way. He didn't use his right hand.
All right. Let me restate that very quickly for the record because we hear a lot of this and that.
Okay.
You have grabbed the yardstick with your right hand on the bottom and your left hand up top and demonstrated how someone would hold the rifle, typically.
Correct.
And while I hear you say you do not recall everything that he did, you are clear in your memory, are you, that he, being Michael Keetley, did not use his right hand
He did not.
at all?
No.
Okay? And so whether he grabbed it with one hand and put it in the truck or...
Objection, Judge, speculation.
Well, rephrase.
I'll rephrase. Okay. What he did with his left hand, you do not recall at this point in time.
What do you do with this left hand?
Objection, Judge Leading.
What he did, you do not recall.
I can tell you.
Rephrase it again.
Sure. Tell me what he did with his left hand. He's not using his right hand. Tell me. All right. Now, first of all.
Get his right hand like this.
Okay. Stop.
And then I reached out with this.
All right. If you don't mind, stop right there so I can get it. You've got your right hand kind of up by the middle of your chest in kind of a fist or limp type of stance. Am I describing that correctly?
Correct.
Now he takes the firearm with his left hand, the rifle. And what do you recall him doing?
At that point, I don't remember if he looked at it with his.
Objection, Judge, speculation.
Well, sustained. I'll ask you not to guess. If you don't remember, don't guess.
I'm not sure.
Whatever he did, was he doing it with his left hand?
Left hand only.
Thank you. You can take a seat. You can go back up there. Thank you, sir. I appreciate it. I have no further questions at this time.
No cross-examination.
Yes, Your Honor. Good morning, Mr. Kennedy.
How you doing?
Is it fair to say that this entire interaction that you had with the defendant was approximately 10 to 15 minutes?
Probably.
And this was in mid-November of 2010?
Yes.
And you previously testified that this gun was lightweight.
Yes.
It was only 3 pounds.
Correct. From my recollection.
And is it fair to say that this was a gun that had a curved stock that you could hold it in your shoulder?
Yes.
Or that it fit into your shoulder
Correct.
for another point of contact?
Correct.
And this was a semi-automatic
Yes.
that requires you to pull the trigger every time to fire it.
Correct.
And the defendant told you that he was purchasing this firearm to use it for target practice.
Correct.
You testified that you met in this Winn-Dixie in Riverview.
Yes.
The defendant drove there
Yes.
in his white pickup truck.
I believe it was white. Yes.
And you testified on direct examination that you showed that he held his right hand up kind of at his chest area.
Yes.
So it's fair to say that it was not deformed, he was holding it in a manner like normal.
Correct. I would not say it was deformed. Just not working properly.
And you don't really know what issue the defendant may have had with his right hand because you never touched it or shook his hand.
No, I did not.
Nothing further, Your Honor.
Were you right?
You were asked a question about this starter rifle for children.
Yes.
Does it function or look like a black pump action shotgun?
Not at all.
Nothing further.
May this witness be released by the defense
Yes.
and released by the state?
Yes, Your Honor.
Thank you, sir. You may step down. You may be released as a witness at this time. And ladies and gentlemen of the jury, as promised, it is perfect time for our morning break. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid all reports of the case outside of the courtroom. It'll be one of those when you're ready. It usually takes between 20 and 30 minutes, though, for all of you to be ready. So we'll see you back here when you're ready. All rise for the jury. Jury has exited. Everyone may be seated. Let's go ahead and take a break. I know that you reserved on arguing your JOA, but I want to give the staff a break, and especially my court reporter. So let's go ahead and take a break, and we'll at some point allow you to argue the JOA.
Well, if I can say, before kind of the idea was here, it's not going to be me arguing the JOA.
Oh.
Sorry to disappoint you, but I think you had indicated that however we're going to do it, it may be lunch break or whatnot, but we, of course, agree that I've preserved
Absolutely.
the JOA at the right time.
100% preserved.
So, however you want to do it.
And let me ask you, just while I have you still in the record, you have another witness now. How long do you think before we'll be taking our lunch break?
Let me defer to Mr. Escobar.
Mr. Escobar?
Because one of our witnesses we thought maybe tomorrow is in fact going to be today, I believe.
Okay.
I think my presentation is probably going to be half an hour, maybe 45 minutes at best.
Okay. Well, and then there'll be a cross of that witness,
Yeah.
and we'll take our lunch break after that.
Perfect.
All right.
Yeah, he's got to get back to Tennessee, so we appreciate that.
Okay. No problem. make sure we all get ready in here so that when they're ready. Yes, we're ready.
All right, here's Henry.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Did anyone discuss the case amongst themselves or with anyone else, or was anyone exposed to anything about the case during the last break? By show of hands. Excellent. Let the record reflect there are no hands. Again, thank you all very much. And at this time, I'm going to ask the defense to please call their next witness.
The defense would call Grant Sperry.
Mr. Sperry, welcome and good afternoon, good morning still. If you'll come forward to be sworn. If you'll raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable, and you let me know when you're ready. That microphone in front of you adjusts up and down.
Good.
All right. You may proceed, Mr. Escobar.
Would you please state your full name and address for the record?
My name is Grant R. Sperry, Sperry, and I live at 7859 Cross Pike Drive in Germantown, Tennessee.
Mr. Sperry, what is your profession?
I am a forensic document examiner.
Let's go over a little bit of your background in being a forensic document examiner. Tell the ladies and gentlemen of the jury where you first came into contact with this profession. First of all, let's get your educational background out. Can you tell
Right.
the ladies and gentlemen of the jury your educational background?
Yes, sir. I have a Bachelor of Science degree from the University of New York and Albany, and some graduate study courses through Central Michigan University.
And so tell the ladies and gentlemen of the jury where you first came into contact with this profession of yours.
I was in the Army for a number of years, and I was a military policeman and then a criminal investigator. While I was a criminal investigator, I had always had an interest in white-collar crimes and laboratories, forensic laboratories specifically. So I had an opportunity to apply with the U.S. Army Criminal Investigation Division's forensic laboratory in Georgia at the time. And I applied specifically for forensic document examination and was accepted and began training over 42 years ago now in that field.
Was your first full-time training a residency type of training that you went through?
Yes, sir. It was a 2-year in-residence program dealing strictly only with forensic document examination. So it broke down to pretty much 104 weeks, 4,000 some hours of study and work and research in the area of forensic document examination under the supervision of forensic document examiners with many, many years of experience.
And was that with the U.S. Army Criminal Investigation Laboratory?
Yes, sir, it was. The U.S. Army Criminal Investigation Laboratory at the time, and I believe still, is the executive agency for the Department of Defense in terms of forensics. So at that period of time, anything forensics that needed, whether it's crime scene processing that needed the laboratory to assist or laboratory analysis itself, the U.S. Army Criminal Investigation Laboratory supported the Navy, the Marines, Air Force, of course the Army.
It's my understanding that you also had some training with U.S. Secret Service. Is that correct?
Yes, I've completed the two-week orientation course, the Secret Service and document examination, and also completed the fundamentals of document examination of the FBI up in Washington many years ago. Upon completion of the 2-year program, of course, as the military will do, I was tested periodically over the course of that 2 years, and having successfully completed the training at the end of 2 years, I was certified by the Department of the Army and the Criminal Investigation Division as a forensic document examiner, and thus began my career in that area.
It's my understanding you've also participated with many other departments in this particular field as well. And let's just go over them if we can. The Georgia Bureau of Investigation Laboratory, could you explain to the jury your contact with that particular outfit?
Yes, sir. The Criminal Investigation, the Army Laboratory, was headquartered at the time in Fort Gordon, Georgia, near Augusta, and eventually went to Fort Gillem, Georgia, which is in Atlanta. And as such, we did a lot of training and work with, actually we trained or helped train some of the folks at the Georgia Bureau of Investigation Laboratory. So received training at that laboratory and assisted them in some of their cases in addition to receiving training.
Did you also have contact with the Royal Canadian Mounted Police?
Yes, sir. And I did some training up there with the Royal Canadian Mounted Police, both in Montreal and in Ontario, I believe. There we're just exchanging ideas, exchanging processes or ideas about processes, how to work different types of cases. We occasionally would get documents that were counterfeited or supposedly counterfeit from the Canadians, and so we needed to be aware of the various document issues that they encounter, and likewise they with us.
The International Symposium of Question Document Examiner in Washington, D.C. I know you had some contact with that outfit, correct?
Yes, that's one of many, many, many symposiums and conferences and professional organizations that I've attended. That particular one brought together forensic document examiners from around the world. And again, it's a kind of an exchange of ideas, of techniques, of technology, trying to bring everybody up to speed in the world of forensic document examination.
Mr. Sperry, I'm not going to go through all of them, but I'm going to go through one last one. There was one that you participated in called the First European Conference of Handwriting Experts in Germany.
Yes, sir. When I was stationed in Germany and actually managed the document division of the U.S. Army Crime Lab in Frankfurt for 5 years. And we helped set up and organize the first international meeting of forensic document examiners in Europe at that point. So again, examiners from the European theater from the various countries get together, and we would, it was kind of neat because we had flags representing, like the UN, representing all the countries, and would go over ideas and technology and the state of the art and discuss specific cases.
Now, you've been in private practice since, I believe, 1993, but you also were the manager for the U.S. Postal Inspection Services Forensic Lab in Tennessee as well, correct?
That is correct.
Explain to the ladies and gentlemen of the jury your position there with Tennessee.
Yes, when I retired from the U.S. Army in 1992, I took a position with the U.S. Postal Inspection Service Crime Laboratory in Memphis. That crime laboratory had the responsibility of supporting not only postal inspectors and their investigations in the southeastern part of the country, but also other agencies as need be. Kind of like the FBI does in a way. They support other agencies. Our laboratory also supported other agencies, whether it was the state of Florida or Alabama. When there was support needed and we could provide it, we were able to provide it, we did so. And so at that particular laboratory, I was hired as a document examiner, eventually became manager and document examiner, along with others at that facility until my retirement.
And you've been in private practice, I guess, since 1993, is that correct?
Yes, sir, that's correct.
Tell the ladies and gentlemen of the jury how many times you have testified in your profession before the courts of this country.
I've testified, provided sworn testimony approximately 380 times, all courts of the military numerous times, federal courts in a lot of different locations, state courts all over the country, international courts, Hong Kong and Europe.
How many times were you refused or not allowed to testify in your particular specialty?
Never.
Let's talk about the number of times that you have examined documents and testified. More for the government than the defense?
Oh, yes. Yes.
How much more would you say?
Well, probably 80% government, 20% defense.
I know that you are members, or you are a member of associations. Would you just give the jury just a small smattering of the associations that you're a member of?
Yes, sir. I'm a member of the American Society of Question Document Examiners, which is the oldest professional society of forensic document examiners in the world, and also past president of that particular organization. I'm a member of the American Academy of Forensic Sciences and a fellow with that particular organization of that document section. I'm also board certified by the American Board of Forensic Document Examiners, a board certification comprising not only testing, of course, and written tests, but also practical application tests, and then finally an oral argument. That certification is maintained through continuing education every 5 years, and I'm current as far as that goes with respect to my certification. I'm also a member of the Southeastern organization, Southeastern Association of Forensic Document Examiners, and affiliated with the American Society of Testing and Materials, and more recently the Scientific Working Group on Document Examination.
You have had some publications as well, is that correct? Again, just a small smattering of the publications that you've been involved in.
Yes, sir. I've prepared and presented a number of papers over the years at conferences, published in 2 peer-reviewed journals. One is the American Society of Questioning Document Examiners Journal, and the other is the Journal of Forensic Sciences.
What is it that you do as a forensic document examiner?
My responsibilities as a forensic document examiner include the examination, comparison, and analyses of handwriting, handprinting, and machine-produced material for the purpose of either identifying or eliminating a particular person or machine as the source of a questioned writing or document. Additionally, I conduct a number of examinations with respect to inks, non-destructive examinations, alterations, manipulations, page substitutions, identification of copiers and printers, and those types of things. Essentially, forensic document examination addresses 3 major areas. One is authenticity, the other is origin, and the third being dates. So authenticity would be along the lines of, did this person, or the writings made by supposedly this person, write this question material? That's authenticity. Origin is the origin of a particular document. Was this document prepared on this printer? Or what printer was it? What's the origin of this particular printed product? And the third being date. Is the date reflected or alleged on a particular document consistent with having actually been written on or about that date, or has it been backdated or postdated?
I will tender for any
No
questions.
questions.
Mr. Sperry, were you requested in this particular case to examine some documents that were of material issues in this case?
Yes, sir.
May I approach you on? You may. I'm going to show you what's been marked as State's Exhibit number 191. I'm going to ask you to pull the documents from that particular exhibit and tell me whether you recognize that exhibit.
Yes, sir.
Is that the photo pack presentation of Gonzalo Guevara?
Yes, it is.
Okay. Let's talk a little bit about when you saw that original document in this particular case. Could you tell the ladies and gentlemen of the jury where it was that you saw those original documents in this case?
I was first exposed to these documents at the State Attorney's Office, at an office within the State Attorney's Office here in Tampa.
And in coming over to the State Attorney's Office, what did you have to bring with you in order to be able to properly examine those particular documents?
A truckload of equipment consisting of digital microscopy or microscopes, what we call a video spectral comparator, which is used to differentiate inks, among other things, has all sorts of capabilities, but that's one of the uses. Also brought, of course, a scanner, a camera, and a device called the electrostatic detection apparatus, which is an instrument that is used to develop and view impressions or indented writings that occur. When you write on a piece of paper and there's a piece of paper under it, frequently you'll see impressions of what you were writing on the paper beneath it. Many times you won't see it, but they're there, and this instrument helps.
When you brought all those instruments with you, I'm going to show you what's been marked as Defense Exhibit number 40A through P. Did you scan these particular documents that are on State's Exhibit 191? Did you scan those documents? And if you did, would you please tell the jury why you did so?
Yeah, so these are state's defense exhibit 40A through P are images of documents, the originals of the photo lineup that I examined. And they were scanned at various resolutions to capture as much detail as I possibly could from a scanner. So in this particular instance, I scanned these documents at 1,200 pixels per inch. So a very, very good resolution. Purpose for that being that subsequently, when I returned to Memphis, I would be able to examine those, conduct further analyses based on the high resolution images. And these are just some of what I scanned. I scanned the images at various resolutions. I used different capture devices as well.
And do those that are in your possession right now, do they fairly and accurately depict at least some of the ones that you scanned in your analysis in this case?
Yes, sir, they do.
Your Honor, we would move those into evidence.
Any objection?
No objection, Judge.
They'll be admitted. What was the number?
Looks like it's
40 A through P.
Defense composite 40A through
P.
P. Admitted.
Mr. Sperry, in addition to defense exhibit number 40A through P, were you also provided by the state attorney and from the Hillsborough County Sheriff's Office some known handwriting
Yes, sir.
of Detective Victor Lugo?
Yes, sir. Purported by Detective Lugo.
I'm going to show you what's been marked as defense exhibit number 39A through T, and ask you if you could please take a look at that and see if in fact those are the documents that were provided both by the state attorney's office as well as the Hillsborough County Sheriff's Office as purported writings of Detective Victor Lugo.
Yes, sir.
Do those fairly and accurately depict what was provided to you in this particular case?
Yes, sir, they do. They also bear my exhibit designations and initials in the PDF.
And where are those exhibit designations on those exhibits?
Down at the bottom of each page.
And did you put those exhibit designations yourself
Yes, sir, I did.
on those documents?
Yes, I put them on with a PDF. They're on
With
PDF,
PDF.
yeah, so they're printed on
Your
there.
Honor, we would move now defense exhibit number 39A through T into evidence.
Any objection?
No objection, Judge.
Will be admitted.
Let's go with instructional form. Now, Mr. Sperry, I'm going to ask you to, Your Honor, may I ask him to step down?
You may.
I'm going to ask you to please step down, and we're going to be discussing some documents.
That yardstick is up there if you need a pointer.
We got him. He's got a pointer.
Oh,
Mr. Sperry, is this a document that you were familiar with in reference to the Gonzalo Rivera photo pack?
Yes, sir. Yes, sir, it is. It's the identification or viewing instructions for the photo lineup.
And were you asked by our office to examine that document and certain areas of that document and make some comparisons?
Yes, sir.
Okay, and so what areas were of interest in this particular document?
Well, I examined the entire document, but the principal areas were in the lower portion of the document, beginning with Gonzalo Guerrera, specifically in the area of the overwriting, the alteration in this particular area, as well as an examination of the inks to determine whether or not I could distinguish any of the inks, one from the other, as having originated from different writing instruments.
And so, before we go on too far, tell the ladies and gentlemen of the jury how you do that as an expert in your field.
With respect to, you're talking about inks
Yes.
primarily? Okay, with respect to inks, forensic document examiners, unless they are also analytical chemists of some sort, they conduct non-destructive. I conduct non-destructive examinations of the inks. And I use instruments that are capable of rendering differences in inks by filtering out certain waves of light. In other words, I use an instrument that applies a number of filters that allows me to view how the properties of the various inks appear using an alternate light source through filters. I also conduct microscopic examinations to determine whether or not there are any obvious differences microscopically, not only in the inks, but of course the writing instruments.
I'm going to show you before we get too far along here. Well, let's go to the next document if we can, and then we'll introduce. Thank you. Is this another document that you were asked to take a look at and to focus on in this particular case?
Yes, sir.
And what area of that document were you asked to focus on and to look at for your analysis?
Primarily the writing itself, the number 4, what appears to be perhaps a number 4, Gonzalez Herrera entry, and the number 3 up in the right-hand side as well.
And did you do the same examinations that you had done on the previous document with reference to those particular writings as well?
I did the same examinations, and I actually conducted comparisons between those as well.
I'm going to show you now what's been marked as Defense Exhibit number 38, 1 through 9, and ask you, and ask you if you recognize Exhibit 38, composite.
Yes, sir. These are images or photographic reproductions of the charts that I made to be used at trial.
Okay. And do they fairly and accurately depict what you made in the form of charts?
Yes.
We would move, Your Honor, at this point in time, Defense Exhibit number 38, 1 through 9.
Any objection?
No objection, Judge.
That'll be admitted at this time.
Chart number 1, please. Mr. Sperry, tell us about this particular chart that we have before us right now on this particular screen, and tell me what it represents.
This is obviously an enlargement of the area on the photo identification lineup instruction sheet that deals with the alteration of the numbers. And also it serves to show a little bit of similarities between the writing instruments. On my left, you can see where I've increased or decreased the contrast so that it's clear to see perhaps the downstroke of what appears to be a 4 and the left side of the 4, and of course you have the terminal stroke of the 4, as well as what I believe are the initials of Detective Lugo, the upper right-hand side. On the number 3 at the far my right, over in this area here, these arrows point to portions of what is the number 4 that's beneath it. So you have the downstroke here of the 4, downstroke on the right side of the 4, and it crossbars over this area. And this is a terminal stroke there that's also part of that stroke. Even though the 3 that's been overwritten the 4 appears to be obviously much darker, actually microscopically and instrumentally there's no distinction in the ink. In other words, it's the same ink or similar ink and similar or the same writing instrument. And what's occurred is a overwriting at least twice, and you can see a little bit of that up in here. So anytime you deposit more ink and more ink and more ink, it's obviously going to get darker. And that, in my opinion, explains that. But the testing that I did non-destructively, I could not distinguish, I couldn't separate the inks as being from 2 different writing instruments.
And you specifically looked for that to see if, in fact, it was 2 inks
Yes.
that used the 4 initially and then the 3 being the overwriting number, correct?
Yes, sir, I do.
Okay. And so you believe that, based upon your analysis, it was the same ink and the same writing instrument?
The same or similar.
Same or
I
similar?
could not, it's perhaps helpful to explain what we do in terms of ink examinations. Ours is more of a discriminatory type of examination. That being that you could have a box of big pens writing different documents, and they're all going to have the same microscopic and visual or instrumental features, no matter how you filter it, because they're the same chemical composition. But if you have one instrument that is different from another, they may look both black, but they are in fact different writing instruments. So we discriminate. So when I say that I could not discriminate between a set of inks, I'm basically saying I can't microscopically or instrumentally find any differences. So they're either the same pen or certainly the same batch that produced it.
Chart number 2. Okay, let's take a look at this and tell me, if you can, what this particular chart displays.
Well, this actually illustrates, and you'll see it enlarged perhaps later, two differences in writing instruments. So the Gonzalo Guerrera entry signature here and the, believe it's Detective Lugo's signature below it are actually written with two different writing instruments. So Guerrera's signature was written with what appears to be perhaps a roller writer type of instrument, and the signature of Lugo, as well as other entries, such as the badge number, were written with perhaps what appears to be a gel type of writing instrument. And they display two different types of distinct differences, not only instrumentally but microscopically. You can see the difference pretty clearly. So this is kind of an overview of that. And that would include these up here. So the entries up here, the 3, the 4, and the initials are consistent with the Lugo signature as either the same or similar writing instrument, but different than the Gonzalo Guerrera signature.
Chart number 3. Okay, so we've got some arrows here that you pointed. Tell us what the purpose of this particular analysis was.
Further illustrate some ink differences. This particular image in the upper right, of course, these are again enlargements of the area. This particular on my far right is an enlargement of the area of the signature of Guerrero and Lugo where they intersect. And I thought that would be a good place to point out some differences between the two writing instruments.
Could you point out again the actual area that they intersect for the ladies and gentlemen of the jury?
This area right in here. So,
meaning this loop that comes this way and this loop that...
Right, the looking at the G in Guerrera and the terminal stroke of the word Lugo, the name Lugo coming through. So that's this area here.
And so you focused on that particular area?
Right. So the yellow line reflects the Guerrera, and the red line, arrow, reflects the Lugo signature entries. This image here, both of these signatures, when subjected to infrared light and viewing any luminescence properties, they both luminesce, both inks luminesce. This is a little brighter luminescence on Lugo signature versus the Guerrera signature, so that's a difference there. That would indicate a different writing instrument. And also, microscopically, down in the lower right, you can see the Guerrera signature that comes through here has more of a mottled or patchwork type of characteristic to it. It's kind of muddied in this area. Whereas Lugo's signature, the writing instrument, this is somewhat characteristic of this type of writing instrument, has kind of clear, if you look up here in the arch, you'll see that it appears to be like tracks on either side of the center portion of it. Kind of like a squeegee effect. So you're kind of squeezing that dark ink out to the edges. And that's consistent throughout the Lugo signature, and some other writings. And there, of course, I'm illustrating as well some of the similarities that exist between the Lugo signature and the initials of Lugo, as well as the alteration and the underlying for.
Point out some of those similarities between the Lugo 3, 4, and his initials, and his signature that appears here in this area.
Well, the primary area, I guess, would be on the initials, the last portion, the upstroke of his initials on my far left. You can see those track marks on either side of the center portion, just a darker area. You can see it down here in the initials of the J, or whatever it is, first initial of Lugo's name, as well as the downstroke of the 4. And from a previous chart, you can see that the 3, when you contrast it, also has these track marks. And you're seeing that right over in here, among other places, in a Lugo signature.
Chart number 4. Mr. Sperry, we've got some yellow, we've got some pink. You use these two colors to differentiate certain writings on this document, correct?
Yes, sir.
Explain to the ladies and gentlemen of the jury why you did that and what the focus is of the different colors.
This is a summary of the differences in inks that I found represented all the way through pages 1 through 6 and the photo identification instruction sheet. So this portion up in here with the pink and the yellow is obviously the identification instruction sheet. The lower left portion is from photo lineup picture number 3. And then these numbers, even though they're a little larger, obviously I enlarged them, but these numbers are from the upper right-hand corner of each of the 6 pages in the photo lineup. The pink essentially represents one writing instrument. I could not, of all these, the ink here, here, and here, I could not distinguish it coming from more than one pen, a writing instrument. So they're similar, or the same writing instrument was used. Where you see the yellow, these also were either the same or similar writing instrument to each other, but different than the pink. So essentially what I'm showing here are 2 different writing instruments, 2 different inks.
Number 5. Number 5, tell us why we selected these 2 documents, one being picture number 2 in that photo lineup, as well as then again the photo lineup viewing instructions.
Yes, sir. Okay, so this deals with examining a document for indented writings or impressions. Again, you can write on a piece of paper. Frequently, if there's something underneath it, it's going to record the image of that latently. It means it's not visible maybe by sidelight or instrumentally I can make it visible if it's there, hopefully. So I examined all of the documents. I screened all the documents for indented writings, specifically focusing on this particular document as well as some of the others in an initial screening. I was running out of time at the point of my exam at the end of the day, so I didn't subject them all to what we call the ESDA exam, but I did examine them all. So I examined this document for indented writings. This document I examined for indented writings. So now we're oriented, and we can go to the next slide.
Next slide.
The 2 types of exams, I conducted both an exam using sidelight or oblique light, using an instrument as well as handheld flashlight of sorts, and then I conducted an exam using the electrostatic detection apparatus. 1, 2, and 3 lines show where the impressions of the 4, the Lugo signature, and the entries at the bottom of the identification page, where they are found indented on photo number 2. And the impressions, the resulting impressions, are clearly here in what's kind of a pinkish colored image. The 4 and the signature and the badge number in this area here, right here. And then the bottom portion of the document that has the the person identification information. Those are all developed impressions on this page. What notably is not developed is there's no 3, which means that at some point later, certainly not at that time, but at some point later, the 3 was overwritten.
So are you telling the ladies and gentlemen of the jury that this particular document had been placed over the photograph number 2 at the time that those particular writings were made?
Correct.
And you can tell the jury that that is the case because of what?
Because of the developed impressions. I actually superimposed, did some other work, obviously, instrumentally as well as digitally. So I superimposed this 4 with the 4 that is underneath the 3, and they're the same. I wanted to make sure that it wasn't an extraneous 4 from something else. Similarly, I digitally superimposed the entries for the Lugo signature as well as the person identification entries that were imprinted or indented rather on photo number 2.
Next. Number 7. Tell me the analysis that was being conducted here in number 7 in reference to the strokes to make these particular writings.
One of the questions that was posed is if I could determine forensically whether or not a particular writing was made before or after another writing. So what you're seeing here is in a small area enlarged again, similar to what we saw before with intersecting strokes of the Guerrera and the Lugo signatures. I'm using a function called lab colors that makes it jump out a little brighter for all of these entries. And incidentally, when I conducted these examinations and used instrumental examinations and filters and things of that nature, I conducted that type of examination over the subject area entirely. In other words, I didn't mix filters and do a filter here and then do a filter over there. The whole area was exposed to whatever filter I happen to be using. And so the purpose of this is to try to show the sequence of strokes. The writing pressure that is demonstrated throughout Lugo's signature and some of the other writings on the photo identification page, as well as the numbers, I guess, of each page that are attributed to Detective Hugo, indicate that a much relatively heavy writing pressure is used. Writing pressure is unique to the individual. Sometimes it's unique to the writing instrument and the individual combined. You get 2 different types because writing instruments put ink on paper in different ways. In other words, by that I mean some writing inks will flow under the paper, others you have to actually press a little harder. But Detective Lugo, overall, his signature and some of the other entries are heavier writing pressure than what I found in the Guerrero signature. So what you see here is Lugo's signature, that portion of it, and down for it is Guerrero. At this point, these arrows represent 3 intersecting points, this being the primary, in my opinion, because it shows the stroke coming clear through either direction. So what I'm looking for there is, and it also shows some pretty good distinctions in the inks, as a matter of fact, in that image. This is an enlargement of this point of intersection down below. Both writing instruments are ball instruments. So there's a little revolving ball down the tip of the instrument, and then when you write, that ball rotates and it puts the ink on the paper. So when you write on a piece of paper, and depending, of course, on the backing, what's underneath that paper, is it a pad of paper or is it a hard surface, you're going to create an impression in the paper, kind of like a canal or a ditch that you draw onto the paper. That's actually what you're seeing. And the writing instrument that was used for Lugo's writing, his signature, creates a pretty deep canyon, if you will, whereas Guerrera's is a much lighter pressure. When you have intersecting strokes, when one stroke crosses the other stroke, there is frequently, especially depending on writing pressure, a ridge that's created. As an example, if the Guerrero's signature was made first, and Lugo's signature was made second. Coming through here on the Lugo signature, what you're going to see is a ridge that is up against, kind of at an angle, against the direction that the Guerrero signature was. So it kind of cuts through that little canal and creates its own ridge as it goes through. If the Guerrero signature, or if the Lugo signature was made first, and Guerrero followed it, then what you'll see is the Guerrero signature written with a different writing instrument and lighter pressure would certainly skip in this area here, because he's cutting across a pretty good sized ravine. And what that causes the pen to do is jump a little bit. You'll see either a skipping over in this area. I didn't see that. Now what I found was that the Lugo signature was written after the Guerrero signature. So Guerrero's signature was written first, and the Lugo signature was written after the Guerrero signature.
8. So now we have a chart or a diagram here talking about the alignment of writings. Is that correct?
Yes, sir.
Tell the ladies and gentlemen of the jury why that's important.
Part of what we look for in the identification of handwriting, one of the many, many characteristics that are looked at and examined, have to do with baseline habits. People have baseline habits. In other words, you've got a baseline that's printed on a piece of paper. Some people write above it, some people write below it, some people write through it. It's just whatever your habit is. You take away a baseline, then there's what we call an imaginary baseline. So if you write your name here and you're asked to write something below it, then more than likely your habit is to just space down and write below it, so that what you end up with is kind of a similar angle to that baseline. So if this was a 4, and this was the Gonzalo Guerrero entry here, so you have very similar alignment there as you would expect in a person that is writing at a single sitting, perhaps. The 4, or the X, then on your perspective, and I'll get into that, up in this area, this is showing you, that's an enlargement of it, showing you the actual writing, and this is a direction lower right showing you how the thing was made. So the stroke is made from right to left, up, and then the downstroke of the 4. What you're seeing on the lower left-hand side is the embossing, and I've reversed it so it's actually right reading, so you can actually read what it is. When you write, again, on a piece of paper, you're going to create the reverse image, or the embossing, as you write on the other side of the paper. So this is the back of the photo number 3, the back of it. And what I'm seeing here is very, very similar embossing. In other words, there's not much variation. It's consistent in terms of its level. So it's indicative of similar pen pressure, similar type of writing instrument perhaps, and similar writer maybe, because it's right across and very, very consistently made. Okay.
So are you telling the ladies and gentlemen of the jury that there is consistency between this 4 and the signature of Gonzalo Guerrero?
Yes, you have a little darkening area of the 4 here. You have a darkening area of the downstroke of the of the Gonzalo area here, and you have some darkening here. And you have light areas, and the contrast or the consistency of the embossing. And when you look at it at an angle, you can see the depth of it. It's pretty consistent all the way across. So there's also no or negligible bleed through. So the ink is not, the pressure is not significant enough to force a bleed through. In other words, the ink is actually being absorbed and coming out a little bit out of the back of on the back of the piece of paper.
So did we ask you to perform this analysis to try to have some evidence to determine whether the 4 that we see on this particular document was in fact written by the same person that signed their signature?
Yes. And the answer is, I don't know if it's the same person or not as far as the 4 or the X goes. And here's the problem. If you take away Gonzalo Guerrero, we're just looking just at this. Who made the 4 or the X? There's really little value, identification value in this. X4, it's kind of like a 1 can look like an L, an S, and a 5, depending on who's making it. A 1 and a 7 sometimes, especially if you European handwriting. So there's not a lot of individual writing features and characteristics in a single form like that. So fortunately, in this case, I was able to go to other areas and look at evidence. So I know that based on the writing on the instruction sheet, that Detective Lugo has fairly heavy writing pressure. And I know that Guerrera does not. So I could look at that. I could also look at the baselines of the writing. And I could also look at the number 4 that Guerrera makes, how he makes a number 4 and how he makes an X. There are only so many ways you can make an X. Only so many ways. And that's why this is not really, the 4 itself is not really identifiable. But when taken in context, it's the signature, let's call it the number 4, the embossing, the consistency there. It's indicative of a single writer across there.
Now, we talked earlier on that the Hillsborough County Sheriff's Office and the State Attorney's Office had provided you some documents to take a look. They were photographic copies, correct?
Yes, sir.
That were provided to you concerning that number 4 or that number X. Could you tell or show the ladies and gentlemen of the jury, and we're going to do it at the next one as well, but this is a nice big 4, so it's kind of nice to see it. And tell the ladies and gentlemen of the jury the distinctions that you found in what the government was providing in reference to the number 4 or an X and what we see on chart number 8.
Well, going back to how this particular 4 or X was made, begins over here, and you can notice that there's very little, if any, reach, if we're calling it an X, over to the right-hand side. So you're missing the right-hand side of the X, if this is an X. And also, it's much larger than what you'll see that were provided of Detective Lugo's X's. This, because of its size, it's made a little differently, believe it or not. The movement's the same, but it's larger. And you're going from what we'll see in Detective Lugo's X's, which are essentially a really quick single movement because they're real small X's, to a relatively large letter size, numeral size, if that's what it is, there. So those are a couple of distinctions. And, of course, the similarities that exist not only in the inks, but in the writing pressure across the whole signature and number 4 area.
The writing pressure is a very important factor, is it not?
It certainly is in this case, yes.
Number 9. What do we have here, Mr. Sperry?
Right here, upper left, we have the 4 Gonzalo Guerrero entry from photo number 3 in the lineup, and this is another enlargement of the 4 or the X, as you prefer. This entry down here on my lower left that's labeled Q1, this actually came from the first from the instruction sheet, photo identification instruction sheet. And you can see the writing pressure that's there, but it's made very similar. It's made this fashion. Coming down, so the right side, the upper side's made, coming up and going through. And presumably, everything else I received were copies, but presumably these others are made in a similar fashion. So you have a more area over here further to the right, starting and coming down, and more clearly X's. And it's not as compressed. It will be compressed. I've seen some of the Lugos that are compressed, but certainly the 4 or the X up in this area is uncompressed. In other words, it's not writing. This crossbar is not way up here at the top. And then I was also asked to look at the number 4. Could it be a number 4 written by Lugo? Well, it's obviously different than the number 4s that Lugo writes this particular entry here.
missing on this particular is the, what do you call this leg that is missing here?
Which leg is that, sir?
Excuse me, this leg.
This leg. So that's your upper right. Let's call that the upper right. We've got an X. That's an X. Then you're missing up in here at some point.
So were these upper legs pretty consistent with Lugo in the documents that were provided by the government?
Yes. Now, Detective Lugo makes a lot of X's, and so there's some variation in there. But overall, this type of representation is not represented in Lugo's known writings.
No further questions. Thank you.
Can I take my seat?
Yes.
Mr. Sperry, you want to, unless you need the...
Judge, I actually do need
Okay,
that,
we'll
so I don't
leave
know
it.
if they want to help me or
They will. We'll help
okay,
you.
thank you. I
Do
appreciate
you want
that.
the witness to remain down?
Actually, I do.
Okay.
Can you go to chart number 4? And that's, you said, was taken from 191, is that correct?
Correct.
The photo pack that was sent to Mr. Guevara, is that correct, Mr. Sperry?
Yes, ma'am.
And I want to go to the different inks. So we're dealing with the instruction sheet as well as the photograph that Mr. Guevara picked out and signed. So this down here is actually from the photo number 3 of the defendant's photograph. Is that
Correct.
correct?
Yes,
That
ma'am.
has, you're saying that this, whether it's an X or a 4, is with the same ink as Gonzalo Guevara, the signature. Is that correct?
Correct.
As well as from the instruction sheet where the name is printed, as well as an X here and a signature and the date. All of that is the same pen. Is that correct?
Same
Not
or similar?
same pen.
Similar.
Because of the ink. You're saying that
Correct.
it could be, you saw no disparity in the
Right.
ink looking at it under your machine. Is that correct?
Correct. Instrumentally, I could not discriminate.
So if someone was at the hospital and had one pen and had shown a photo pack to someone and put an X or a 4 there and handed the pen to the person to sign the photo that he picked out, that would be consistent, correct, of using the same pen. This is the same ink, correct?
Yes, if that's all we were looking at, that's right. Just the inks, yes.
Just the inks, correct. And then, if you then went to the instruction sheet and wrote out the witness's name, and again, put an X for the witness to sign there using that exact same pen he had at the hospital, that would be consistent with similar ink. Is that correct?
Correct.
And then he signed and dated it after the witness signed here, again, same ink, correct?
Yes.
And then afterwards, if you use that same pen, these are all from the different, in the upper left-hand corner.
Right hand.
He wrote, right hand, I apologize, thank you. 1, 2, 3, 4, 5, 6.
Yes.
That would all be consistent with using the same pen or similar pen, is that
Yes,
correct?
yes, ma'am, that's correct.
And then if he took the photo pack and the instruction sheet back to the office with him and somehow used a different pen, that could also account for this being different ink. Is that correct?
Yes.
Okay. I'm going to go to chart number... Can you go to chart number 1? Thank you, Mr. Sperry. So this 3, 4, you're saying that the 4 is first, correct?
Correct.
And then there's a 3, is that correct?
Overwritten a couple times.
Overwritten a couple of times.
Yes, ma'am.
So if somebody had made a mistake and when he was looking at this and mistook this X for a 4 and wrote a 4 down and then realized it should be a 3 and then twice went over it with a 3, that would be consistent with your examination, is that correct?
Yeah, certainly one explanation.
One explanation, yes. Because you weren't there, you don't know.
No, no ma'am.
And I'm going to show you, I'm going to go back to that photo pack where the 3 and 4 is the original document that you scanned. What's above the 304?
Looks like initials.
Initials. Are you familiar with looking at all these documents? Sometimes when somebody makes a mistake, they put an initial over it to document that they have made a mistake. Is that correct? Have you seen
Yes.
that before?
Absolutely.
And that's what that is right there, is initials over the 4 that is overwritten by the 3, correct?
Well, I don't know when the initials were placed there, but
Correct.
they're there.
Right, but you know that the 4 was there first, and then
Yes.
somebody wrote over it in heavier ink, or maybe twice,
Correct.
to denote that the 4 was a mistake, possibly.
Possibly, yes.
Can we go to chart number 3? And again, we're talking about the instruction sheet. So again, when you're saying that the Lugo intersecting this, again, it would be, and that this is later in time, correct?
Yes.
So also consistent with if he had written this at a later time, is that correct?
Yes.
Then the person, Mr. Guevara, is signing it.
Right. I mean, it would appear, just based on the inks, that Guevara signed,
Guevara.
Mr. Guevara
Yes, sir.
signed a blank form. In
Correct.
other words, the time he signed it, those numbers weren't there, just based on the inks.
Yes, sir. And then if we go back to, can you go to chart number 3? So, I'm sorry, chart number 9. Apologize. So chart number 9, again, this is the photo. When you, up the upper left-hand corner is the photo number 3, where you have said that this, you don't know what this is, whether it's an X or a 4. You cannot definitively state that, correct?
Not definitively, no, I
Okay.
cannot.
And so when you're looking at that, have you seen in documents where somebody are preparing documents and they need a signature, where somebody has put an X mark to denote a signature?
Frequently.
Frequently. And in fact, on this very document, the instruction sheet, next to Mr. Gonzalo Guevara's signature, is there an X that is placed there?
Yes, there's a small X there.
Okay, and then next to it is a signature, correct?
Correct.
Okay. And then, did you ever take a look at Daniel Beltram's photo pack that's already put into evidence, States Exhibit 195, another document prepared by Lugo, where Daniel Beltran signs on this viewing instruction? What's right next to where he signs?
Clearly an X.
Clearly an X.
And
So-
that's part of the problem, see, because this is from page 1 of the instruction.
Yes,
This is
sir.
the instruction, and it's clearly an X, whereas that is not.
Correct. So I know that you got a bunch of different documents that had different X's that Lieutenant Lugo had made during the course of his employment. Is that correct?
Yes, ma'am.
And there are variations in all of those X's. Is that correct?
There are variations, correct.
And part of one of the underlining premises in forensic document examination is that a person, even though it's one person writing, there are natural variations in a person's own handwriting. Is that correct?
Absolute natural variations, a term we use frequently, yes.
And so if I were to write my name, Michelle Doherty, 20 times, all of those M's, even if I have a swirl for my first initial, if you looked at all 20 of those M's, they could look different. Is that correct?
They may and probably will look a little bit different, and that's why the characteristics of your entire signature would be evaluated.
You would have more letters.
Correct.
And
More features.
to look at. In this case, you're just looking at one. So if I just wrote the letter M 20 times, I'm not a robot. If you put all of those M's over one another, they wouldn't line up exactly, correct?
Correct.
Human beings have a natural variation.
Right, they do, and the problem is though too. This particular construct, if it's an X, is a little outside of Detective Lugo's variation.
Things can affect somebody, the way somebody writes. There are external factors that can affect variations in handwriting. Is that correct?
Oh, absolutely. Yes.
For instance, the surface that somebody writes on, that can affect the way you write a letter. So if you didn't have a hard surface, say if you were just holding the paper like this and you're getting ready to hand it and you put an X, may not all of your pen make contact with every part of this page?
That's correct. And one aspect of that, though, is that I would expect if this was made on a different writing surface than this, then I would see evidence of that, in the embossing that occurs on the back of it. And I didn't. It was really consistent.
But it's possible, is that correct, that he could have been writing on, theoretically, that if he's writing on something like his hand and just puts an X, that can account for not all of, so if he normally comes all the way up here, that maybe it just shows that. Is that correct?
That's a possibility.
Possibility. So can we go to, let's see. We go to chart number 8. So one of the things that went into your opinion was that this has also, you talked about that baseline. We tend to write in a straight line, is that correct?
Yes.
So again, we don't know if this is a 4 or an X, is that correct, sir?
It's not 100% correct.
Right, so and I see, like if this is a 4, this is where your invisible straight line is, correct?
Right.
But if this is an X, that line is going this way, right?
Correct.
So in that case, if it's an X, they would not have that baseline alignment, and it could be possibly another person writing this than Gonzalo Guevara. Is that correct?
That's correct, but to arrive at that type of finding, you'd have to ignore some of the other factors that went into this. So, yes, could this be an X written on a different writing surface? Yes. Could this be an X written at a different angle? Yes. But the evidence doesn't support that, I don't believe, because again, you have parallel baseline habits, you've got the embossing that's very, very consistent, and you've got a letter formation, whether it's an X or a 4, that's made outside the range of variation that Detective Lugo demonstrates.
Right, but if it's a 4, if it's not a 4 and it's an X, you don't have that baseline alignment. Is that correct?
That would be correct.
Okay. And sir, I want to ask you if we can go to chart number 6. So again, when you're saying that the viewing instruction, and let me get that again. Again, at another, going back to hypothetically, if somebody were back at his office and he now was looking at that photo and put that 4 down,
Here, right?
this,
Okay.
it just means that when he did that, this instructional sheet happened to be directly over photo number 2. Is that correct?
Correct.
And then when he signed his initials, even though it's not perfectly aligned, he may have shifted the paper, it then ends up also being indented there. Is that correct?
Correct.
And when he's writing the rest of this information, it just means that he either shifted the paper or something, that the indentations did not come out on the rest of this photo. Is that correct?
Correct.
The only indentations are of,
This entries.
right.
So the entries that are made with a different writing, or the entries that are made with a different writing instrument.
But as to whether or not that's a 4 or an X, you can't definitively say whether or not it's a 4 or an X. Is that correct?
Definitively, no, I cannot.
And going back to that photo that's on picture number 3, you can't definitively say that the person who signed Gonzalo Guevara is the person who also, whether it's an X or a 4, did this mark. Is that correct, sir?
Definitively, no, I cannot.
And when were you hired by the defense attorney?
I'm sorry?
When were you hired by the defense?
prior to February, I believe it was January of this year.
And right now, you are in private consulting, is that correct, with your
Yes,
own
ma'am.
company?
Yes, ma'am.
You charge $300 an hour, is
Yes,
that
ma'am.
correct? And at the time of your deposition, you had already done 13 hours, is that correct?
That sounds right, yes.
So, which would equate to $3,900 at the time of the depo?
Correct.
And that does not include your time for testifying today, is that true, sir?
No, and it doesn't include analysis that was conducted after the demo.
Okay. Thank you so much, sir. You can go ahead and have a seat.
Mr. Sperry, I'm gonna bother you one more time. Can you just stay there?
Do you want this stuff up here?
Yeah, you can leave this stuff there, please. Can I go to chart number 4? I believe you just indicated on cross-examination that it is your belief that at the time that this document, at least the time that this particular writing took place, that this document was in that area in blank?
Correct. If this is the same writing instrument used, yes, it would have been. Because these in pink were filled in later.
No further questions.
May this witness be released by the defense
Yes, Your Honor.
and by the state?
Yes, sir.
Thank you, Mr. Sperry. You may step down. You may be released as a witness at this time. If you need to go back around, you got everything?
I got it.
All right, thank you. Ladies and gentlemen of the jury, it is time for our lunch break. I'm going to give you, it's almost 12:30, so I'm going to give you to 1:45 for lunch. Please do not discuss this case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid all reports of the case outside of the courtroom. We'll see you back at 1:45. All rise for the jury. Jury has exited. Everyone may be seated. Now, assuming we do get started back at approximately 1:45, is the video the only thing you have left, or you also have the live witness?
Yeah, we've got Creeper coming.
You've got what?
Creeper.
Creeper. That's it? The video, our video, and Mr. Creeper?
Yeah, Creeper and
Mr. Baia.
Mr. Baia and the video.
Okay, so that's probably not going to take us till, even if we start at 1:45, till 5 o'clock, I don't suspect. So it sounds like we may be sending them home a little bit early today. That's all right. What I'll do is, since that's probably what we can discuss jury instructions, and we can allow you to argue the JOA at that time. So we'll let everybody have the full lunch break.
Judge, we've spoken to the prosecution. Can we do the jury instructions tomorrow?
Yeah,
We
we can.
We're going to have some time tomorrow.
We can.
We were doing some other things.
Yeah, in fact, I think we're starting late tomorrow, so we could come in. It probably, I'll ask you all, but I don't think it's going to take more than 30 minutes. So we could come in 30 minutes before the jury and discuss jury instructions. I don't have a problem doing it tomorrow,
There are
though.
a couple of jury instructions that are special jury instructions that we're considering, and we'll let them know today.
Yeah, absolutely. I want you all to have the benefit of all that so that you can consider it before we actually have the charging conference. But I don't have a problem having a charging conference tomorrow. We're not going to charge the jury until Friday morning. All right, well, have a good lunch, and we'll pick up at 1:45. Thank you.
Rick, do you want to make sure that all of your exhibits here, because I should
Yeah,
say
I'm gonna put all that.
too. What's that? Oh, yeah, no problem. No problem. We're not ready. Oh, there's Mr. Keetley. Lieutenant, can Aiden come down? Aiden? I know this is your last day with us and how interested you are in being a lawyer in the criminal justice system. Come up here. I want to give you a pocket constitution. In my opinion, the Bill of Rights is the most important document in our criminal justice system. And this is a pencil I bought at the U.S. Supreme Court. It says U.S. Supreme Court. It's kind of like a little gavel. And obviously, I've never used it. I bought it a long time ago. It's been on my desk. I want you to have it.
Thank you.
You're very welcome. I'm so glad. I'm so glad. You are family. You're welcome here anytime.
At the end of court, I'd like you guys to stay behind because I want to get some pictures of Aiden and the
All right. So I think we were waiting on a couple jurors. What to get to that? Well, he just brought a group up. That's the first group. Oh, that's the first group. Okay. Once we get all the jurors, is the defense ready?
Defense is ready.
We doing a live witness or a video first?
We're doing a live witness.
We're going to introduce a couple of exhibits called live witness and the video.
Exhibits, live witness, video.
Yes, we've already done that.
They're talking about something different. They're talking about the redacted copy of the medical record and then these or something.
Oh, no problem. Sure.
7A. He has 3 others that we have no objection to.
Now, what is you intend to introduce this through the next witness?
Omar Bailon. That is Omar Bailon, also known as Creep.
Creep or creeper?
Two different, he goes, I think, by both.
Is there more than one picture here, or is just one
No,
picture?
just one.
Oh, stick. Which one is? Yeah, there's 2 people in it.
Creep is on the left.
So that's him.
Yeah.
Do we know who that is?
Yeah, he's a rapper. I'm not going to elicit anything from him, but he is a rapper and a gang member.
Let me see the other pictures.
And then I think they already have some other ones that they introduced, Judge.
Yeah, there were, I thought, like 3 of them already introduced.
Those are the ones that have no objection. You want to see the ones that were introduced already?
Yeah.
Danielle, please.
And you don't have any objection. This is the street sign with the bullets in it. I remember that or hearing about that before. This is a picture of a group. It's a terrible picture. You can't see anything in it.
You'll see the next one.
Oh.
Bingo. These are the other two.
These are the ones that are already
Yes.
admitted.
Yes.
All right. So, what's the objection?
Relevance.
Anything else?
I don't know.
In light of all these others?
And cumulative.
Yeah, I like that one.
And
What-
prejudicial, Judge.
Well, how is it more prejudicial if you want to go down that path than say this one's already in evidence? So how does this one make it any more? How is this more prejudicial than this that's already in evidence?
It's making it overly prejudicial, Judge, having multiple.
Well, I think that goes to your cumulative objection.
Yes.
What's the point? It's cumulative.
Well,
I mean, these
if
are-
we want to talk about cumulative, we've had a lot of cumulative photos here, right? From
Well-
the medical examiners, if we recall. We took one picture out of the medical examiner's office.
You're right.
And everything else was allowed in.
Yeah.
Cumulative or not.
Yeah.
And so, it's a picture of him throwing gang signs. It's,
All right.
It's important.
Whoops,
Whoa.
I'm sorry.
That's okay, that's okay.
There's already one in of that, so I'm going to take one out of the defense. I took one out of the medical examiner. I'm going to take that one out as cumulative.
This one?
Yeah. They're all here? State ready?
We're ready, Judge.
Defense ready?
We're ready, sir.
Let's bring in the jury.
Oh, wait, Judge, before we bring him in,
Hold on.
we're calling him an adverse witness.
Judge, I would object. I think there needs to be some kind of establishment of that.
We have my...
It doesn't there have to be some showing? I mean, you call him, and then if he becomes, then you can approach?
Not necessarily, but there's a factual basis going into it, as we have here.
What's the factual basis?
All you have to do is, it's got to be a witness that is associated with the government's case. And he's been associated from the very beginning as a witness for the government's case. He actually testified for the government at the last trial. And I can show you, if you'd like to read Earhart on that particular issue, it's pretty clear.
Well,
This paragraph, starting with
He's not a
section.
state witness, Judge, in this case.
He has been. He has been. All they have to do is be affiliated.
well, Earhart says hostility is determined at the time the witness testifies and is not presumed.
Okay, that, keep reading, that's hostility. We're talking about adverse for,
612.1, it's in mode and order of interpretation presentation, page 755 of the 2022 edition of Earhart.
What page, I'm sorry, Judge?
755. Let me ask the defense and their excellent research team whether they've found a case that specifically says that a witness called by the state or more on point with this, besides what it says here about a witness identified with an adverse party, which is what you're proceeding under. But then it gives examples of an employee, a coworker, a relative, or having a romantic interest in an adverse party. It doesn't have the specific here where the witness was previously called. And I know that's not going to come up often because you don't often have multiple trials.
Judge, I can tell you, we litigated this extensively in the Reeves case, and every police officer, every witness that they had given us as a witness in the theater were adverse witnesses, and we led them all the way through. If there's any affiliation between the witness and the government, they're an adverse witness.
Let me ask this: did the state list this witness on their witness list?
Did, and actually testified for the government at the last trial.
All right. Anything else from the?
Judge, he is separate and apart from a law enforcement officer. Defense counsel citing to the Reeves case. Yeah, under Earhart, those law enforcement officers would qualify under.
But it's not just them. I mean, it even suggests romantic relationship, co-worker, relative. So that's not just police
Have
officers.
any of those things with Mr. Bailon.
No, but he's listed on your witness list.
We have multiple people. They're going to call Detective Tom Dirks. He's on our witness list, and he's on.
It sounds like you agree that they can treat him as a witness associated. You just said that you distinguished it by saying he's not a police officer. So when you call a law enforcement officer, that distinction no longer exists. So under those circumstances,
Yes, under those circumstances, but not just because he's on our witness list.
no, I'm going to allow it.
Thank you.
You get to ask leading questions on cross too. So you both get to ask leading questions. It's not the end of the world. All right. Let's bring in the jury.
All right, jurors entering.
Or not.
I apologize.
That's okay.
Just a moment.
You're fine.
Now we're ready.
All right.
All right, jurors entering.
Jury is present and seated. Everyone else may be seated this time. Ladies and gentlemen of the jury, good afternoon. Welcome back. Did everyone have a nice lunch? Excellent. We are going to now, I need to ask, as you know, did anybody discuss the case amongst themselves or with anyone else? Or was anybody exposed to anything about the case? Or did anybody do any research related to the case during the lunch break? By show of hands, let the record reflect there are no hands. Again, thank you all very much. Now I'm going to turn to the defense and ask them to please call their next witness.
Yes, Your Honor, before we do, we're going to admit defense exhibit number 15 into evidence. And we are going to also admit defense exhibit number 14 into evidence. 15 are the medical records of Daniel Beltran. 14 are the medical records of Gonzalo Guevara that have been redacted for sensitive information.
Any objection from the state? 14 and 15, defense 14 and 15 will be admitted at this time.
And I'll place them with the clerk.
All right. Now I'll ask that you call your next witness.
The defense would call Omar Bailon.
Omar Bailon. Mr. Bailon, good afternoon and welcome. If you'll come forward to be sworn as a witness wherever you're comfortable, if you'll face me and raise your right hand. Thank you. You swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, if you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone in front of you adjusts. It may have to come down some. You ready?
Yeah.
All right, you may proceed.
Good afternoon, Mr. Bailon.
Good afternoon.
Please state your full name for the record for the ladies and gentlemen of the jury.
Omar Bailon, Bailon.
And Mr. Bayon, would you please tell us where you currently reside?
507 Ocean Mist Court.
Were you residing at that particular address in November of 2010?
Yes, sir.
And would you tell the ladies and gentlemen of the jury who lived in that home besides yourself?
My parents and my sister at the time.
Okay. Was your girlfriend also staying there?
Not living with me
Where she was staying there?
that night, yeah.
Okay. You are familiar, are you not, with the ice cream man that used to frequent that Ocean Mist community, correct?
Yes, sir.
Mr. Keetley, this gentleman right over here.
Yes.
You knew that he would come by your house for purposes of selling you ice cream and nachos, right?
Yeah.
In fact, you bought ice cream and nacho for yourself numerous times from him, correct?
Yes, sir.
And you would interact with him in that purchase of those particular items, correct?
Yeah.
And you would go up to that truck and you would have conversations and make your selections for Mr. Keetley to provide those items to you.
Yeah.
And you would pay for those items, correct?
Yes, sir.
And not only would you do that for yourself, but I believe you had children there in that home that I believe was it your girlfriend's children?
Yeah.
And you would at times do the same thing. You would buy ice cream and other products from Mr. Keetley for the children that were at your house.
Yes, sir.
And Mr. Keetley, in making those particular sales to you, would actually park right in front of your house, 507 Ocean Mist.
Yeah.
In fact, during all of those transactions that you had with Mr. Keetley, you got along very well with Mr. Keetley, correct?
Well, yeah. Normal relationship customer.
In fact, you thought he was a pretty nice guy.
Yeah.
Now, you were aware, were you not, that at some point in time, Mr. Keetley was robbed and shot numerous times, correct?
Yeah.
And you became aware of that because you had actually seen some posters that had been placed around the community with Mr. Keetley's picture on it, asking for donations to help him out during that process, right?
Yes, sir.
And that picture that was on that particular display, you recognized it immediately when you saw that picture as being the ice cream man that you had purchased ice cream from, not only for yourself, but for your family as well.
Well, not immediately. I don't know if it took me a couple of times, but I didn't recognize him immediately.
Okay. Now, it was not uncommon in this Ocean Mist community for anyone back in 2010 to see the Ocean Mist street signs having bullet holes in them, correct?
Yeah.
I'm going to show you what's been marked as Defense Exhibit 7E. And I'm going to ask you, first of all, before we display it to the jury, I'm going to ask you if you recognize that particular photograph.
Yeah.
In fact, that photograph you had on your Facebook, correct?
Yeah.
Okay. And does that photograph fairly and accurately depict what was on your Facebook back, years ago in 2010 when you were putting things on your Facebook?
Yeah.
Okay. Your Honor, we would move 7E into evidence.
Any objection?
No objection, Your Honor.
7E will be admitted.
Now, Mr. Bailon, what we're looking at here is, I guess, a series of Ocean Mist signs with bullet holes on those particular signs, correct?
Yeah.
That you had posted on Facebook.
Yeah.
Could you tell the ladies and gentlemen of the jury why you posted this on Facebook?
It was just a picture. I didn't think much nothing of it.
You didn't think much of it.
No, it was just a picture. My
Were the
neighborhood.
bullet holes significant to you?
No.
They
There
were
was,
not.
there was bullet holes all over the signs, all over Ruskin, not just Ocean Mist. So it's not just in Ocean Mist. You can go to Ruskin and drive and find bullet holes in every sign.
So did you have on your Facebook signs of every place?
No,
in-
because I'm not from the whole Ruskin. I was from Ocean Mist.
You're from
That's my
Ocean Mist.
street.
Okay. Now, Ocean Mist, that community, that street specifically leading to your house and going past 604 is a very dark street, is it not?
Yeah.
Domino Drive is just one street over from Ocean Mist Drive, right?
Yeah.
And your nickname back in 2010 was what? Creeper, what was it?
Creeper, but they call me Creep for short.
So your nickname was Creeper, but they called you Creep for short.
Yeah.
Okay. And is that something that you also displayed on your Facebook
Yeah.
back then?
Yeah.
Okay. Now, Mr. Bailon, you were affiliated with certain gang groups, correct?
Yeah, I know some of them.
I'm going to show you what's been marked as Defense Exhibit 7B and ask you, it's been actually introduced into evidence already. I'm going to ask you to take a look at that and see if you recognize that exhibit.
Yeah.
And is that an exhibit of yourself that you posted on Facebook?
Yeah.
Okay, let me have it back so that we can display it for the ladies and gentlemen of the jury. That is you in that picture?
Yes, sir.
Okay, and you are doing something with your right hand. Would you tell the ladies and gentlemen of the jury what you're doing with your right hand?
I'm throwing up Ocean Mist.
You're throwing up ocean mist. What does that mean, throwing up ocean mist?
I don't know.
Well, why would you want to throw up those fingers like that? What does it signify to anybody that is seeing that?
To me, it's my street where I grew up at.
Well,
That's how I see it.
Well, I realize that ocean mist is your street.
Okay, well, that's what I'm throwing up, Ocean Mist.
So you're throwing up that sign indicating, hey, everybody out there, ocean mist is my street.
Yes, sir. Not mine, but where I grew up.
I'm going to show you two photos at this point in time. I'm going to show you Defense Exhibit number 7D and Defense Exhibit number 7E, and ask you to please take a look at both of those exhibits.
Yep.
You recognize those?
Yes, sir.
Okay. And do those exhibits fairly and accurately depict a group of individuals that you're familiar with?
Yes, sir.
Your Honor, we would introduce now Defense Exhibit number 7D and 7E.
No objection, Your Honor.
Thank you. 7D and 7E will be admitted.
Let's first look at 7D, which is a little bit dark, correct?
Yep.
And it's kind of hard to see the individuals, but this was one that you posted yourself on your Facebook as well.
Yes, sir.
Is that correct?
Yes, sir.
Okay. And this is a clearer picture of what's depicted there. Is that correct?
Yes, sir.
Okay, so let's look at, and this is 7E. So let's take a look at 7E. And would you tell the ladies and gentlemen of the jury if you find yourself in that photo?
Yes.
Okay, and if you can, may I ask the witness to step off, Your Honor?
Yes, you may say.
I'm going to give you this this little ruler here, okay? And I want you to show the ladies and gentlemen of the jury where you're at in this particular photo. That's you. And are you doing anything with your hands there?
Well, I think so, no?
So you're not doing anything with that left hand. That's you're not throwing signs there on the left hand.
No, I do that. No. I got a feeling this one, and I don't know what I'm doing.
You don't know what you're doing with that hand. Okay. And who's beside you?
Diego,
Do you know? Does Diego have a last name?
Lucas,
Okay. And
Walter Lucas.
Walter Lucas. Okay. And do you know if Walter Lucas is throwing any signs there?
Nah, this person's not throwing anything. He hasn't seen anything. I don't know what's going on with
Okay. And then you have is Jose Rodriguez anywhere there?
that. I'm not sure if that's him or not. It looks like him, but I'm not too sure. It's kind of blurry.
Okay. There's some other individuals right over here that are doing something unique with their hands. Do you see these two gentlemen over here?
Yeah.
What are they doing there?
Looks like they're doing the west side.
A what?
West side.
West Side.
Yeah.
You're familiar with West Side, right? Because you're affiliated with West Side.
Yes, sir.
And so I want to know, tell me what they're trying to tell us by throwing those West Side.
You would have to ask them. I don't know what they're trying to tell you.
You don't know. So when someone from West Side throws a sign with their hand, you just don't know what that means.
Not what they're trying to do about it.
Okay. You may take your seat. Thank you. Now, those individuals that are there that you recognize and that you identified for the jury, they are members of the Ocean Mist gangsters, correct?
No.
Lucas is not?
No.
Diego's not?
No. I don't know what you mean by members. We were just a couple of friends. I mean, a group
Well,
of friends. What do you mean by
Ocean,
members.
Ocean Mist gangsters. Is there any reason why you decided to pick that name, Ocean Mist
No.
gangsters?
No. You got Charlie Brown in the gang, and that's not a gang.
But why the word
I
gangster?
don't know.
Do you know what the definition of the word gangster is?
Yeah.
What is it?
Well, not the actual definition, but
What is it? You don't know.
no.
Now, you have OMG tattooed on your body, right?
Yep.
Would you tell the ladies and gentlemen of the jury where it's tattooed?
On my chest.
On your chest. In addition to that, you have on your arms tattooed Ruskin Outlaw.
Yes, sir.
Do you know what the definition of outlaw is?
Against the law, I guess.
And can you tell the ladies and gentlemen of the jury why you would want a tattoo on your arm that said the word outlaw?
I don't know. I was young. I got a lot of tattoos when I was young. Dad. I don't know why I got them.
You have another tattoo that says FTW. Where's that at?
I'm armed.
And what does FTW mean?
Fuck the world.
And you have another tattoo, I don't know where this one's at, Trust No One.
Yes, sir.
Where's that one at?
On my shoulder blades.
On your shoulder blades.
Yeah.
So you got them on each shoulder blades? Now, you would agree that yourself and Jose Rodriguez, you all were affiliated with both the Ocean Mist Gangster and West Side Gangsters, right?
Yeah, we know them.
When did you join these groups?
I didn't join those groups. I knew them.
When did you become affiliated with them?
Since middle school, when you know them, you meet different people in middle school.
Now, on one of these Facebook posts that we just took a look at, you are certainly promoting the Ocean Mist or OMG, right? You're promoting that
I
to
don't know about promoting. What do you mean by promoting?
Well, you're trying to let everybody know that you're part of this group, right?
I guess.
You've already indicated that that block was your block, right?
Not mine, where I grew up.
Well, you remember in that block there being tags, right? Gang tags?
Yeah.
Okay. And those gang tags are put there in your community for a reason, right?
I guess.
And you've seen some West Side gang tags in that community, right?
Yes.
You've seen some Ocean Mist gang signs in that community, right?
I don't recall.
You don't recall?
No.
Just West Side.
Yeah.
Okay. Let's go to November 25th of 2010, which was the night of this homicide, okay? You were at home, is that correct, with your girlfriend?
Yes, sir.
Am I correct?
Yes, sir.
And you had an individual by the name of Diego Lucas come and bang on your window at about 2:30 in the morning.
Yes.
Because Diego Lucas wanted to advise you of what had happened.
Objection, Judge, hearsay.
Rephrase.
Did he wake you up?
Yes.
Okay. And immediately after he woke you up, did you go somewhere?
Yes.
And where did you go?
Over to the house where it happened.
The 604.
Yes.
And when you got there, there was crime scene tape up.
Yeah.
You realized that there had been a shooting.
Yeah.
You realized that there was still a body on the porch, right?
Yes, sir.
And so you were there outside of the house along with other individuals, right?
Yes.
A bunch of individuals, right?
Yeah.
And you were there as early as 2:30 in the morning, and you stayed there all the way until when you went to District 4.
Yes.
Is that correct?
Yes, sir.
You're going to do your approach real quick?
Yes.
Just as a precaution. Mr. Bailon, on the 25th, you had a conversation with Jose Rodriguez where he told you that Jose Rodriguez did not recognize the shooter in that homicide, correct?
Yes, sir.
Now, that Thanksgiving morning, there was a great deal of rumors going and circulating.
Objection, Judge, may we approach?
Yes.
Now, I'm going to show you what's been marked as defense exhibit number 10. See if you recognize that exhibit.
Yeah.
You received that exhibit, correct?
I believe so.
And I'm going to display that exhibit for you. You remember that that exhibit had been forwarded to numerous individuals, correct?
Yes.
And so when you looked at that exhibit, you realized that that exhibit was being given to many individuals.
Yeah.
Is that correct?
Yeah.
And you certainly recognized the picture on that particular text, correct?
I don't recall if I recognized it right away or not.
Or did you recognize, do you recognize that person as the ice cream man?
It's been a long time. I don't remember. Yeah, I'm guessing, yeah.
Now, did you determine who you had gotten that text message from?
No.
Did you even try?
No, I don't remember.
Well, when you get a text message, you look at your text message and you can identify
Yeah.
who sent it to you, right? I mean, you
Yeah.
do that often, right?
Yeah.
Because you want to know, if you're getting a text message, you want to know who you're going to text back,
Yeah.
right?
Yeah.
Well, since you do that and you got this text message, did you tell Detective Lugo, hey, Detective Lugo, let me help you out?
Hearsay.
You tell Detective. I'm going to sustain that.
Did you discuss this text message with Detective Lugo?
No.
Did Detective Lugo ask you any questions about this?
Objection, Judge.
I'm not asking for the question. Did he ask him any questions? It's the predicate question.
All right, let him finish the question before the objection so I can hear the whole question.
Did-
Go ahead, ask the question.
Did Detective Lugo, without telling me what he asked you, did Detective Lugo ask you any questions concerning this text?
I don't remember because I got the message after I spoke to Detective Lugo that morning.
But by same question, did Detective Lugo ever ask you any questions
I don't-
about this text?
I don't remember.
I don't have any further questions.
Cross?
Good afternoon, Mr. Bailon.
Good afternoon.
You were shown this photograph on direct examination, and you said you didn't really recognize who that person was. Is that correct?
Yes, ma'am.
Because you only bought ice cream from the ice cream man in the purple truck about 2 or 3 times, correct?
Yeah, a couple of times.
Being affiliated with a gang is different, much, much different than actually being in the gang, correct?
Yes, ma'am.
Can you explain to the jury what it means by being affiliated with a gang versus being actually in a gang?
Well, from my understanding, from being affiliated, you know certain people that belong to a gang. You might hang out with them from time to time. You might talk to them. And being an actual member, you got to put in work or missions or actually hang out with them all the time and listen to what they say. They got certain rules and stuff you got to abide by when you're a member.
Did you personally know Daniel Beltran?
Yes.
Did you personally know Juan Guitron?
Yes.
Did you personally know Sergio Guitron?
Yes.
Did you personally know Richard Cantu?
No.
Did you personally know Gonzalo Guevara?
Yes.
And did you personally know Jose Rodriguez?
Yes.
Did you personally know Ramon Galan?
No.
Any of those individuals that you actually knew, none of them were ever in a gang, correct?
No.
None of them were in West Side Gang.
No.
Ocean Mist Gangsters, is that a real gang like Sir 13?
No.
What is it?
It was just a bunch of, I guess, well now we're adults, but a bunch of teenagers that grew up in the street, and just a group of us. Just
A group of kids that were living on
we all-
Ocean Mist?
Yeah, we all lived in the neighborhood, and it was just a bunch of us that hung out. Just a group of kids, crew kids. Not to call it a gang, we call it a crew, a posse. You can call it whatever you want.
On the night of November 24th of 2010 and the early morning hours of November 25th of 2010, you were not at 604 Ocean Mist Court.
No.
Anything that you know about what happened there is what you learned from what somebody else told you.
Yeah.
You never saw the shooter.
No.
You have no idea what happened on that porch.
No.
You never even heard gunshots.
No.
You did go down to the Hillsborough County Sheriff's Office and you were interviewed by law enforcement
Yes, ma'am.
and you cooperated with them.
Yes, ma'am.
This man right here in the cream colored sweater, you're not friends with him, right?
No.
You never even knew his name
No.
Thanksgiving morning of 2010.
No.
Were you aware that he knew your nickname?
No.
Were you aware he was asking people around about you?
No.
I would assume since you're not friends with him, you were never over at his home.
No.
Publishing States Exhibit 115. Bailon, that is your last name, correct?
Yes, ma'am.
507 Ocean Mist, that's your address, correct?
Yes, ma'am.
Joelle, that's your father's name.
Yes, ma'am.
Rosa, that's your mother's name.
Yes, ma'am.
May I have a moment, Your Honor?
Yes.
Mr. Bailon, at the time, November of 2010, you were dating a female with the last name Jaramillo, correct?
Yes, ma'am.
Her first name Samantha.
Yes, ma'am.
What was the name of her boyfriend prior to you dating her?
Andres Gonzalez.
And November of 2010, he was in prison, correct?
Yes, ma'am.
And can you describe him? What background, what race was he?
He was Hispanic.
How tall was he?
5'5", dark skin complex. Bald headed.
What kind of build was he?
He was medium built.
Say there's nothing further, Judge.
Redirect.
Mr. Bailon, when I asked you initially on direct examination whether you had purchased ice cream and nachos from Mr. Keetley numerous times, you told this jury yes, numerous times. Remember?
Yeah.
And now the prosecutor gets up here and asks you, Mr. Bailon, you've only purchased from Mr. Keetley 2 times, and you say yes.
2 or 3, she said.
2 or 3. So which one is it? Is it numerous or is it 2 or 3? Because they're light years apart.
A couple is 2, 3 could be numerous, so I said 3 or 4.
Oh, so to you, 3 is numerous.
To me, to several people too, not just
And
me.
that was what you had purchased for yourself, correct?
No, not for myself.
Well, you did purchase for yourself from
Well,
Mr.
yeah,
Keetley.
but I purchased for other people too.
Yeah, you did.
You asked me if I
You
would
purchased
take
for the little kids as well, correct?
Yes.
No further questions, Your Honor.
May this witness be released by the defense?
Subject to recall.
All right, sir, you may step down. You don't have to wait outside, but you are subject to recall. They'll call you and let you know if they need you to come back. You're welcome. And I'll ask the defense to please call their next witness.
Can we briefly approach?
Certainly. The next witness is going to be a video, so I'm going to read you those 2 instructions again that apply to videos. Prior sworn testimony will be played for you. There may be other lawyers conducting previous hearings or portions of this trial. Please do not be concerned with the type of hearing or age of the case. Instead, focus on the testimony and the evidence presented. Additionally, instruction on edited recording. Members of the jury, you are about to listen to a audio or video. I think this is a video, correct?
Yes, sir.
Video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you listen to and consider this evidence. Whenever you're ready.
Yes, sir. With that, the defense will
Call Jennifer Dyson, Dr.
Jen-
Jennifer Dyson.
All right.
Good afternoon, ma'am. Could you please state your name and spell your last name for the record?
Yes, Jennifer Dysart, D-Y-S-A-R-T.
And what do you do?
I'm a psychology professor
And where are you a psychology professor?
at John Jay College of Criminal Justice in New York City.
Could you please tell us a little bit about your educational background, where you got your undergrad degree, and so on and so forth?
Yes, so my undergraduate degree is from St. Thomas University in New Brunswick, Canada. My master's degree is in brain behavior and cognitive science from Queen's University in Kingston, Ontario. And my PhD is in social psychology, also from Queen's University in Canada.
And I think you told us you're a professor at John Jay College. Is that in New York?
Yes, it is.
And how long have you been a professor there?
There, 14 years.
Tell us a little bit about your work experience.
Yes, so prior to working at John Jay College, I worked full-time at Southern Connecticut State University in New Haven, Connecticut. And at the same time, I adjuncted one semester at Quinnipiac University.
What courses do you teach currently or have you taught in the past?
So at the undergraduate level, I teach introduction, or in the past I have taught introduction to psychology, and I also teach an undergraduate course called Psychology and Law. At the master's level, I've taught courses in psychology and law, also at the PhD or doctoral level in psychology and law, as well as in research methodology.
What was your dissertation on that you prepared and presented to get your PhD?
Sure. So in 2004, I studied the effects of alcohol intoxication on eyewitness memory and eyewitness reliability.
Have you taught classes on eyewitness identification?
Yes, at the master's level.
And what types of topics and issues do you deal with when you're teaching those classes?
So I cover what we would call all the basics with regard to eyewitness testimony, so how memory works, and I also cover the factors that have been shown through scientific research to influence witness testimony and witness reliability.
And are there like specific subsections within eyewitness identification that deal with values or factors that scientists or researchers or professors like you deal with?
Yes, since the late 1970s, researchers in the field of eyewitness identification have really researched and thought about the field in kind of two major categories. So there are factors that we call estimator variables, and these are all of the factors that are related to the witness's opportunity to see the perpetrator at the time of the crime. So was it at night? Was it a far distance? Was there intoxication? So all of those factors that could potentially influence the strength of the witness's memory for the people or the person they saw. So those are estimator variables. The system variables, on the other hand, are essentially the choices that law enforcement make when they're trying to collect the evidence from the eyewitness. What types of questions are they going to ask them? How many photographs are they going to show? How are they going to show the photographs? Who's going to show the photographs? So really what we look at are factors related to the crime and the witness itself, and then we also look at factors related to the police procedures and how they collect that evidence.
Have you been published?
Yes, I published.
And in what journals have you been published?
Gosh, the Journal of Applied Research in Memory and Cognition, Journal of Experimental Criminology, Psychology, Public Policy and Law, Journal of Applied Psychology. There are a few others over the years.
And what research have you conducted?
So I've conducted research, obviously, on the effects of alcohol on eyewitness memory for my dissertation. And since then, I've been conducting research primarily on identification procedures, so the system variables. So research on repeated identification procedures when a witness has the opportunity to see a person in multiple identification procedures. What is the effect on accuracy? I've done research on double-blind administration. So that is when the officer or the person who's conducting the identification procedure, do they know who the suspect is or do they not know who the suspect is? And what influence does that have on the outcome, on witness reliability? I studied 911 dispatchers, is my most recent work, and there are others, sorry. That's okay.
Do you review, or are you a reviewer for any publications?
Yes.
And what does a reviewer do?
So a reviewer is a person who's volunteering their time to essentially look at research that other professors and students are trying to have published. And so what happens is typically the editor or an associate editor of a journal will reach out to people who they believe have expertise on a particular topic that the research is on. And they'll ask, do you have time or expertise to review this article and let us know, is this good quality? Is this a good standard piece of work that's been written? And do you recommend that it should be published? Do you recommend maybe it should be revised and resubmitted? And so the reviewer, usually 2 to 3 reviewers per journal article that gets submitted, makes recommendations to the editor about if they think this is good quality research.
Is that what is called peer review?
Yes, and the process is usually what we call blind. So when a person is doing the reviewing, we don't necessarily know who the researcher is. So we're not biased in our decisions.
Are there particular journals that you do peer review for?
Yes, there are. Usually after a person is published in a journal, that journal then asks them to be a reviewer. So I've reviewed for some of the journals that I mentioned earlier.
Were the articles that you've published, that you've talked about a few of them, were those peer reviewed for those journals?
Yes, they were.
What areas of psychology do you specialize in?
I specialize in eyewitness identification.
And so when we talk about eyewitness identification, tell us a little bit about what does that encompass? What does that encompass?
Sure. So researchers in the field typically come from 2 backgrounds. So there are cognitive psychologists who generally study memory processes and brain function. And I'm a social psychologist, and we study more about kind of how human interaction can influence witnesses' decisions, so how we're influenced by other people and how that can affect or change the way in which we remember things or how we report things. And so the research literature is rich with both of these backgrounds, and so researchers who are in eyewitness identification are generally familiar with kind of both strategies or approaches to the field.
Have you been appointed to serve on any task forces regarding eyewitness identification?
Yes, in 2016, I was contacted and asked if I would be the eyewitness expert on the 3rd Circuit Task Force. That's Pennsylvania, New Jersey, Delaware, and the Virgin Islands. And so I sat on that task force for a little over 3 years.
What was the end result of your work with that task force?
The end result is we released a report in very late 2019, not that long ago, that covered essentially a scientific review of many of the things I'll be talking about today, as well as what the best practices are for law enforcement and kind of recommendations.
Are you familiar with the work of other psychologists in the field of eyewitness identification?
Yes, I am.
And how do you remain current in your field?
Well, there are multiple ways. They're reviewing. When you're contacted and asked to review others' work, you can see what other researchers are doing. Attending conferences. So we have a big international conference every year, and over 1,000 researchers that attend. I have conversations with my colleagues and discuss the research and what's going on as well.
Have you been recognized as an expert in eyewitness identification in courts in the United States?
Yes, I have.
And how many times?
About 65 times.
Your Honor, at this time, I would tender the witness.
Any questions? No questions at this time. Thank you. All right, you may proceed.
Can I just adjust my chair?
Absolutely.
Lower it a little. There, sorry. My feet are on the ground.
The microphone also adjusted.
Wonderful. Thank you.
Before we get into it, are you here to tell the jury whether any of the eyewitnesses that have made a selection in this case are accurate or inaccurate?
No, I'm not.
And why is that?
Because I don't know.
What do you and other experts in your field do to come to opinions or conclusions that you might reach regarding eyewitnesses in a particular case or a particular scenario?
Sure. So when the attorney contacts me or my colleagues, we ask for all of the materials in the case that they have that are related to the eyewitness identification. So any interviews that the witness may have given, all police reports that are related to that, maybe identification procedures, any testimony that the witness may have given. So I ask for copies of all of that.
Did you receive those from me?
Yes, I did.
What did you review in this particular case?
Thousands of pages, probably related to this case. So transcripts, deposition, testimony, and hearing testimony from several of the victims in this case, Gonzalo Guevara, Jose Rodriguez, Daniel Beltran, Raymond Galán. Also testimony from detectives in the case, Kramberger, Lugo, Woods, others. I'm sure that I'm just can't recall at the moment. I've also reviewed very select portions of medical records for Gonzalo Guevara as it relates to alcohol intoxication. In addition to the police report, which the copy I received was about 1,400 pages, so there were, for example, interview transcripts with the witnesses in that document, and so I reviewed that document as well as the 911 call recording.
So let's talk a little bit about memory. How does it work? How does memory work?
So the generally accepted kind of theory of how memory works is that it is in 3 stages. So the first stage is what we call the acquisition or encoding stage of memory, and that's when you're listening, you're paying attention, you're trying to kind of get information into the system. And researchers explore all of the factors that influence our ability to encode information and to acquire information, what we call the estimator variables. The second stage is the storage. So how long is that information that you've hopefully paid attention to and that you've encoded, how long has that stayed in memory before the third stage, which is the retrieval, where we're trying to find the memory, trying to find the information that we have paid attention to. And there's generally 2 forms. That's free recall, like someone asks, what's your name, where do you live? And then there's also recognition. So if you were to look at a crime scene photo or look at a photograph of someone, is that something that you can say, yes, I've seen that before? So those are the kind of the general theory.
Are there some common misconceptions about a human being's memory that researchers have found?
Yes.
And what are those misconceptions?
Some misconceptions are that memory can work like a video recorder, so that if you just kind of try hard enough, you can like close your eyes and like replay kind of the memory back. In fact, memory is more of a reconstructive process. So each time you think of something from the past, you're actually kind of rebuilding that memory, right? Putting it back together. Another misconception is that really stressful or traumatic events are somehow different in that they will never be forgotten, that they're very accurate. And so it's a misconception that we find in our research.
Can a witness's memory change?
Yes.
And how can that occur?
There are multiple ways it can change. First, over time, sometimes we just forget information. and so we're less likely to remember more information as time passes. The other way it can change is if we learn information from other people or other sources after an event, that can actually affect our memory for the original event. So what happens sometimes is people think, oh, where did I hear that story, or who did I hear that information from? And we have difficulty sometimes remembering the context, who told us, or where did we learn that, even though we might remember kind of the gist or the general idea of the information.
What is contamination in regards to memory?
Yeah, very similar to what I was just describing. Is after the original event, the kind of critical event, if you are exposed to information afterwards from other sources, and again, it doesn't matter who it is, where the information comes from, if that information is slightly different than what you experienced yourself and have as a memory, then your memory can become, as we say, contaminated by that information. So it becomes incorporated into our memory, and the concern is that we may not remember where we learned that information. So down the road, when asked to think of something, we believe that we actually saw that original event when in fact it's something we may have learned from somebody else.
Do the studies suggest when a memory is the most reliable?
Well, generally speaking, because of that second stage of memory, the storage, the sooner the better in terms of testing the memory. So right away, the memory is more likely to be accurate. In addition, there's less opportunity for potential contamination, right? So the sooner you can test someone, the better.
Now, I think we were talking earlier, you talked a little bit about what you called estimator variables, and those are things that are just kind of occurring during the crime regarding the victim or the witness and what have you. What are some of the factors that are considered when you're looking at these estimator variables?
Sure. There's a relatively long list that researchers have looked at over the years. One is exposure, so how much time did you actually have to see the events during the original opportunity? And so exposure time, it's probably not surprising when I, for example, tell my students to study hard and study long. The longer they're exposed to information, the more they're exposed to it, the greater the likelihood they will have a good memory for that event. Or the information. So the same is true for witnesses. The longer they have to view something or see something, the greater the likelihood they will be accurate in their recognition later on.
Have there been studies that isolate and identify these issues about the exposure duration, a witness or a victim's ability to see a perpetrator, whether longer or shorter? Are you familiar with the studies that have been done on exposure duration and the reliability of an eyewitness selection?
I'm familiar with studies, yes.
Okay. And are those studies that you rely upon in your field as an expert in eyewitness identification?
Yes.
And is it your opinion that the shorter a witness has, or the least time a witness has to be able to perceive a perpetrator of a crime, the less reliable their identification or selection of a perpetrator may be?
Yes.
How many studies would you say has been done on exposure duration over the years?
Gosh, it's hard to say. It's probably hundreds.
And over the years, do experts in your field get the results of those studies and publish them in a summary form?
Kind of. Well, we conduct what's called meta-analysis, or meta-analyses that summarizes the results of many studies on a particular topic.
And when experts in your field conduct what you call meta-analysis, which is basically a summary of the studies. Does this get published?
Yes.
And is this something you review?
Exposure duration? Yes.
Okay. Let's talk a little bit about exposure duration in our case. Did you review in the material that was provided to you whether or not that factor existed here?
Yes, it's my opinion that it exists here.
Okay, and why is that your opinion?
So the testimony of the victims in this case, who were interviewed by law enforcement and also provided other types of testimony, indicated that they saw this.
May we approach?
Yeah. Why do you have the belief that this factor applies in this case without discussing specifically what any of these victims/witnesses said in the documents you reviewed?
Without saying specifically their recollections of their observation. That there are, yes, it's difficult. I don't know how to answer without
I know.
saying what I know. Based on their descriptions to law enforcement, it's my opinion that exposure duration is relevant here. I'm not sure. I'm not sure exactly the limits on what I'm supposed to say and what I'm not.
So, is it your opinion that, based on what you reviewed, that the eyewitnesses and the victims had too short of a time period to view the perpetrator?
That it was a very short time period.
And that's why you believe this factor applies here?
Yes, that's correct.
Is there a factor within the estimator values that deals with weapon focus?
Yes.
Okay, tell us a little bit about that. What is weapon focus?
Sure. So weapon focus is another estimator variable where witnesses and victims tend to look at a weapon during the commission of a crime when one is being used. And so what the research shows is that witnesses tend to be less accurate in crimes where there's a weapon than crimes where there's not a weapon. And this is, the researchers believe that this is...
Objection. Approach.
Without saying what other research shows, okay, let's just talk about, you talk about how you review research as part of your job as a professor and an expert in eyewitness identification.
Yes.
Okay? So let's talk about, we were talking about weapon focus and we got sidetracked by that, okay? So let's talk about weapon focus. What does weapon focus show as a factor in how it can affect a witness or a victim's identification or selection of a perpetrator?
Yes, so when a weapon is present, there can be a tendency for witnesses to focus on the weapon, and when they're doing that, there's less time to focus on the face or the other features of the person that they're looking at, likely the perpetrator. And so this looking at the weapon it distracts from being able to look at the person's face and can also increase the stress or the fear as well that the person might be experiencing at the time.
Like with exposure duration, with weapon focus, have there been many studies on this issue?
Yes.
And does that get ultimately compiled into that meta-analysis that gets published?
There are two meta-analyses on weapon focus.
That encompass a study of many weapon-focused studies?
Dozens of studies.
And have you reviewed that?
Yes, I have.
your review of the materials in this case, did you have any indication that weapon focus effect may have been a factor without discussing what anybody said? When you reviewed all that information you told us about, police reports, summaries of the victims' statements, hearing testimony of the victims, depositions of the victims, do you have an opinion whether or not weapon focus was a factor in this case?
Yes, I do.
Why is that?
Based on the materials that I reviewed, it's my opinion that it's a relevant factor.
And you talked a little bit, when we were talking about weapon focus, you talked a little bit about the fact that a weapon is involved in a crime increases stress.
Generally, yes.
Is stress another factor that comes into play as an estimator value when we're looking at the reliability or accuracy of a eyewitness selection?
Yes, it's another factor.
And tell us how that can affect it.
So stress or high degrees of arousal in individuals can affect our ability to encode information, that first stage of memory, and also to store that information over time. So that's the general effect of high degrees of stress.
Have there, like with exposure duration and weapon focus, have there been studies conducted on whether or not stress negatively impacts a witness's memory?
Yes, there have.
Has there just been one, or have there been many?
Many, and there's also a meta-analysis that summarizes all those studies as well.
And have you reviewed that meta-analysis?
I have, yes.
In your opinion, based on your review of the materials in this case, do you believe that stress was a factor in this particular case with the victims of this crime?
Yes, I think stress is a factor to consider in the reliability.
Is something that's called own race bias a factor that sometimes experts in your field take into consideration when understanding or evaluating eyewitness identification or selection?
Yes, it is.
Okay. And did that exist in this case?
It's my opinion, based on the review of the materials, that it's relevant, yes.
Tell us a little bit about what that is, own race bias.
So own race bias, also referred to as cross-race bias, is the phenomenon that we are less accurate at identifying people from other racial or ethnic groups. And it turns out it's not just racial and ethnic groups, it's other groups, kind of period. So we tend to be less accurate at identifying others, people that we don't necessarily identify with. So it's the general principle.
Does that mean that somebody's got to be a bigot or somebody that's prejudiced against other races to have this factor affect them?
No. Prejudice and racism have not been shown to be significantly related to the cross-race or own race bias, so that's not a factor to consider in the evaluation.
Have there been studies done on this own race bias?
Many studies.
When did those studies begin?
I'd say they're mid-1960s, probably, the first studies.
Is own race bias, as far as eyewitnesses go, is that something that's a hypothesis, or is that something that has been established by the studies that have been done in this field?
It's an established phenomenon that we're just less accurate at identifying people from other groups.
And so that phenomenon now, is research still done on that phenomenon?
Yes, looking at the kind of mechanisms as to why. So why does this happen? So that's a lot of the research that's happening now.
So just for my edification, so the studies that are being done now is there own race bias It's why is there a race bias?
The majority of the research, yes.
And in this particular case, when we talk about race, are we including just race or are we including ethnicity?
Ethnicity, as I said before, it's different groups. So as long as it's a perceivable difference in groups, then that would apply.
So would that apply to if you have an ethnic group such as Hispanics that are viewing somebody that may be a Caucasian non-Hispanic?
Yes.
And did this factor come into play, in your opinion, in this case?
Yes, based on my review of the materials.
Is another one of the factors that you look at, or the experts in your field look at, when you're evaluating the reliability of eyewitness selection, alcohol and drug use?
Yes.
And I think earlier you had talked a little bit about the fact that your dissertation had to do with alcohol.
Yes.
Tell us a little bit about that.
Yes, so for my thesis work, for my dissertation, I conducted 2 studies on the effects of alcohol intoxication on accuracy. The first was a laboratory study where we had volunteers come in and we randomly assigned them to either receive alcohol or not receive alcohol, so in the control condition. And after we got our participants to 0.08, which is the legal limit for driving, the maximum, in many jurisdictions and where I was doing my research. We then exposed them to a live interaction. So they met with someone and for about 30 seconds, and then about 10 or 15 minutes later, we asked them to describe that person that they had interacted with, and then showed them photographs to see if they could make an accurate identification. In the second study, I actually conducted it in bars. The reason we did that is, why I did that is because in the laboratory we had ethical limits on how intoxicated we could get the participants legally. So 0.08 was the highest we could get them intoxicated. But in the bar, people would show up at the bar substantially more intoxicated than the legal limit. So we had individuals at the high limit of, I think, 0.22 blood alcohol concentration, when the legal limit for driving is 0.08 as a comparison.
How were you able to confirm what the person's drug alcohol level was?
So we had, for part of the research, we had breathalyzers, multiple breathalyzers that we had purchased, and so we actually were able to tell exactly what their blood alcohol concentration was.
And what was the result of your study?
So in the bar study, which is has been published in a peer review journal, what we did is we had someone go up and approach individuals at the bar and ask them if they wanted to participate in the study. They said yes. That person took them to another room. It's kind of like a manager's office in the bar. And then they did what we call a distractor task for about 10 minutes, just to get some time between when they saw the person and then they were going to be asked to remember what they saw. And then they were asked to describe the person that they saw. And then we did what's called a show-up identification. So it's just one photo, just law enforcement technique that's sometimes used. And we asked them with this one photo, is this the person that just brought you to this room about 10, 15 minutes ago? And so what we found is that intoxicated and sober, kind of more sober people were actually both pretty accurate at the correct recognition. So they were able to say, yep, that's the person that I saw before. But intoxicated people were more likely to say, yes, that's the person, when in fact it wasn't. So when we replaced the actual person who had brought them to the other room with a new person that they hadn't seen before, a lot of witnesses in the intoxicated condition made a mistake and thought that that was the person that had brought them there.
And the individual, when you would replace the photograph, was the photograph of somebody that looked like the individual that had had the contact with them prior to them going back in the room and being distracted for about 10 minutes?
Well, it was similar looking, would match the same description.
How about, let me ask you this, besides your studies, have there been other studies done by experts in your field on the effects of alcohol on an eyewitness's ability to reliably and accurately select an individual as the perpetrator of the crime?
Yes, there have.
Okay. And have those been published and summarized or put in a meta-analysis?
There's a review, not specifically a meta-analysis, kind of a review on recall, so a witness's ability to just remember information when they're intoxicated.
How about if the person, in addition to alcohol, has other drugs in their systems, for instance, cocaine? And so in addition to having alcohol in their system, they also have cocaine in their system. Have there been any studies regarding what that effect may have?
So in the eyewitness field, not to my knowledge, because typically in those studies we try to, isolate variables that we're looking at. And so if we're looking at alcohol and its effects, we want to make sure that's all we're looking at. So typically, like in the research that I did, we asked people, have you done any other drugs? Are you on any pain medication? And if they say yes, then typically they're actually excluded from the study because we're trying to isolate the different factors in the studies.
Are there any ethical considerations regarding using illegal drugs to conduct studies in your field?
Yes, it's extremely difficult to do that research.
Did you find that alcohol and or drug use was a factor in this particular case after you reviewed all the information you've talked about?
Yes, I did.
And did you consider that that was a factor that would affect the accuracy and reliability of an eyewitness selection in this case?
That it could, yes.
Excuse me?
That it could affect the reliability, yes.
And what about prior familiarity? Is there a factor that deals with prior familiarity?
Yes. Typically, when you see somebody that you know from the past, it's typically a quick decision, a quick recognition, less than a second.
In this case, was that a factor that you believe could have possibly affected the reliability or accuracy of the eyewitness selection in this case?
Yes.
And why is that?
Based on the materials that I reviewed, it appears there may have been prior familiarity.
And, okay, I'll leave that alone. Now let's talk a little bit about the, I think you told us there was estimator values, which is the estimators regarding the crime itself, and you talked about weapon focus, duration, drugs and alcohol, stress, and prior familiarity, correct?
Yes.
Let me go back to prior familiarity. In your experience, in your training and experience, if individuals have previously seen somebody before, would you expect for them to have some recognition initially?
It would depend on the exposure, but yes.
And would you expect that the individual would say, that person looked familiar to me?
Again, depending on the exposure, yes, you would expect that.
Okay, and then based on your review of this material, was that present? Where somebody said, that person looked familiar to me before?
That's not my recollection of the testimony or the materials that I reviewed.
Did you review the information regarding law enforcement's showing of what are called sequential photo arrays to various ones of the eyewitnesses / victims?
Yes.
And were you provided with a standard operating procedure from the Hillsborough County Sheriff's Office that was in effect in 2010?
Yes, I was.
And I'm going to show you, I'm going to put it up on the screen, Defense Exhibit number 14. Do you recognize that as being the standard operating procedure that you were provided and you reviewed?
The first page of that, yes.
And would you consider, what's your opinion about the standard operating procedure?
Its totality, I think they are recommended procedures. I think for the most part, there might be a few things that I would potentially add, but for the most part, these are recommended best practices in the field.
These were best practices in the field of eyewitness identification and for law enforcement?
Yes.
Now, in this particular SOP, it's got, right under here, under definition, it's got blind administration procedures. And you discussed that a little bit earlier. But what is that again?
Blind administration is when the person who's conducting the identification procedure does not know who the suspect is, the police suspect in the case at the time.
In this case, in regard to the identification procedure that was employed with Gonzalo Navarro, was this standard operating procedure followed?
No.
Okay. And
I think they just need their cord to plug in.
It's going to have to restart. It's going to be a few minutes, Your Honor.
Okay.
If you want to stand and stretch your legs.
Power cord here. Want to use ours?
Are we close?
Yes, we are. Can we approach very quickly?
Yeah. They're going to be able to get it back, so it'll take them a second to get it back where it was. But there's roughly less than 20 minutes left, and this is the last piece of evidence for the day. I'm going to be sending it over when it's over. So that's why I'm not giving you a break. You may be wondering why I'm not giving you an afternoon break, but that'll take 30 minutes, and then you come back and watch 20 minutes. So we'll get you out of here earlier this way. Oh, they're just trying to find where it was. They have to turn the volume on, so you may hear something that you've already heard, but you've already heard it, so not really an issue. They're just going to try to figure out exactly where it was.
Difficult to do that research. Affected the reliability or accuracy of stress and prior familiarity, correct?
Yes.
To have some recognition initially.
It would depend on the exposure, but yes.
And would you expect that the individual would say that he said that person of? Do you recognize that as being the standard operating procedure that you were provided and you reviewed?
The first page of that, yes.
And would you consider, what's your opinion about the standard operating procedure?
In its totality, I think they are recommended procedures. I think for the most part, there might be a few things that I would potentially add, but for the most part, these are recommended best practices in the field.
These were best practices in the field of eyewitness identification and for law enforcement.
Yes.
Now, in this particular SOP, it's got, right under here, under definition, it's got blind administration procedures. And you discussed that a little bit earlier. But what is that again?
Blind administration is when the person who's conducting the identification procedure does not know who the suspect is, the police suspect in the case at the time.
In this case, in regard to the identification procedure that was employed with Gonzalo Navarro, was this standard operating procedure followed?
No.
Okay. And how was it not followed?
It was not followed because Detective Lugo knew at the time who the suspect was in that procedure.
Why is blind administration something that is a best practice? Why is that the best practice?
It's actually a best practice in many fields. It's a best practice also in, for example, pharmaceutical clinical trials. And it's a best practice because when humans are making decisions, sometimes we can see the things that we want to see, and we can be influenced by our expectations. So if you remove someone's expectations because they don't know what answer they're supposed to get, then it completely eliminates that as a possibility as to why the outcome happened, right? Why did this witness or why did this person say a particular thing?
Now, in this standard operating procedure, if we look on the second page, we'll see under E, and where it says include a minimum of 5 fillers per identification procedure. And then it says once the photos are selected, the investigator administrator shall mark the back of each photo with sequential numbers and record the order in which they were shown on the lineup sequence form. Was that done here?
For which particular line?
For Gonzalo Guevara.
No.
And why is this the best practice, that once the fillers are selected, that on the back of the photo they're numbered?
My understanding is that it's practical. What if images were to fall to the ground and now we don't have any record of the order? In addition, another part of the standard operating procedure is that if a witness goes through the sequential lineup and they say, for example, no to everyone, and they say, can I do it again? Can I see those photos again? The standard operating procedure here says that the officer should shuffle the photographs, shuffle the order, and then show it to the witness again. So it would be extremely difficult to record the actual order of the photos that were viewed if they weren't numbered in any way, because they would be in different orders the second time than the first. So that's why it's a best practice.
When somebody's when law enforcement is selecting fillers for a photo pack, are they supposed to select fillers that fit the description of their target suspect, or are they supposed to select fillers that fill the description that was given by the eyewitnesses?
Well, the general recommended practice is that you use the witness's description to make sure that everybody in the identification procedure matches that description, rather than looking at the appearance of the suspect.
And you looked at the fillers that were used in the photo pack that was displayed to Michael Keetley, to Gonzalo Guevara, correct?
Yes.
And did those fillers fit the description of the suspects, the general description that was put out by the suspects when they were interviewed by law enforcement the early morning hours of November 25th, 2010?
Not all of them did, no.
Did you also review a transcript of a recording that was made after the identification procedure had taken place?
With Gonzalo Guevara, yes.
And did you make any note of the manner in which the questioning was made during that recording that is not consistent with the best practices for eyewitness identification procedures?
I can't think of anything off the top of my head that was inconsistent with the procedures.
When a detective is interviewing an eyewitness, should they ask open-ended questions or leading questions?
Open-ended questions.
And why is that?
Because it suggests a particular answer. In particular, if the witness kind of knows not what they're supposed to say, but what the person might be looking for. So if the person who's interviewing them has information, they might seek that as, oh, this person might know something that I either can't recall at this time, or it might have information that I don't have.
And is that an open-ended question or a leading question? The one that suggests the answer?
A leading question.
I'm going to show you the first page of the Hillsborough County photo or live lineup viewing instructions form that was filled out by Detective Lugo and presented, used in the presentation to Gonzalo Guevara. Did you see the section where it looks like somebody wrote over a number?
Yes.
Is that best practices?
I would not consider that best practice.
And going through these photographs, these are the fillers. Did that person fit the general description that was given by the witnesses?
Objection. Proper opinion. No rule,
Did that person fit the general description?
My opinion is no, it does not.
Number 2, did that person fit the general description?
No.
Why not?
The hair is far too long, in my opinion, based on what based on the materials I reviewed in this case.
Showing you number 5. Did this individual fit the general description?
No.
Why not?
He's not husky, large.
Did number 6, did he fit the general description?
No.
Why not?
The age is too old.
Did anybody describe a receding hairline?
No.
Based on your training and experience, your review of the information in this particular case, did you believe that the manner in which this sequential photographic lineup was presented to Gonzalo Guevara was a factor that affected the accuracy and reliability of the eyewitness selection?
It could have affected the reliability, yes.
Now, Jose Rodriguez. Were you aware of whether or not law enforcement conducted themselves in accordance with the standard operating procedure that was in effect in 2010 when they first presented the sequential photo lineup to Jose Rodriguez on November 25th, 2010 at about 4 p.m.?
My recollection is that the standard operating procedures were followed, perhaps with the exception of some of the fillers.
And subsequent to that, is it ever good for an eyewitness to receive information that somebody is actually the perpetrator of the crime before they make a selection?
Objection to form. Good in what regard?
Rephrase, please.
Is it ever appropriate? Is it the best practices for an individual to be susceptible to information saying this is the person that perpetrated this crime before they make a selection?
No, because this is the contamination issue that I discussed earlier, that you would be concerned that the person's memory for the original person and their original memory could be influenced by things that they learn after the fact.
And going along with that, is it ever best practices for an individual to not only get information that a certain person is the perpetrator of the crime before they make a selection process, but in addition to that, after that, get shown one photograph? Is that best practices?
No, the show-up identification that I used in my own dissertation research, the best practice is that should be used only in kind of exigent circumstances or right away after the commission of the crime. And typically it's a live person that law enforcement would use rather than a single photograph.
In this particular case, law enforcement did not engage in the single photo show up to Jose Rodriguez.
That's correct.
The law enforcement involvement had been the blind administration procedure.
The double-blind sequential lineup, yes, with instructions.
Based on your review of the information in this case, is the information that was received by Jose Rodriguez prior to him making the selection from the single photo and the single photo that was shown to him by a friend factors that could have affected the accuracy of his selection of Michael Keetley as the perpetrator of this crime?
Yes.
Now, what about the fact that, what if there's a scenario where law enforcement violates their standard operating procedure? They do not follow that procedure and they don't blindly administer a sequential photo array to a victim. And they have two victims. And they go to one victim and in violation of their standard operating procedure, and they do the sequential photo array, and that victim doesn't identify anybody. And then they go to the second victim, and they show the sequential photo array, once again, not blind, not following their standard operating procedure, and the second victim identifies somebody out of that photo array. Does that mean that the law enforcement officer didn't, even unintentionally, suggest in any manner who the perpetrator may be to the second victim that identified the individual?
No, so the actions in the first identification procedure do not necessarily relate to the second victim in your scenario.
Why not?
Well, in your scenario, we don't know exactly what was said or what was communicated to the witnesses or victims in either scenario. But in my own research on double-blind administration, it's not the case that every single witness who's shown an identification procedure makes a selection and picks someone. So even in non-blind administration, where the person who knows who the suspect is conducting it, there's not always a positive identification of someone in those cases. So we would expect, in fact, almost in half of identification procedures run by law enforcement, that someone's not going to get picked at all.
Is that because some people don't pick up cues?
It's possible some people don't pick up cues. It could be just a weak memory. It could be the wrong person. There are a whole host of reasons why.
Now let's talk a little bit about confidence. When somebody says that they're 1,000% sure or 100% sure, tell us about that a little bit.
So when a witness expresses their confidence or certainty in their identification decision, it's their expression of how they feel, right, about that kind of match to memory. And in kind of general terms, the best practices are when an eyewitness has viewed what we call best practices, double-blind administration, the pre-lineup instructions, they're part of the standard operating procedures. When that victim or witness makes a very confident identification, it's more likely to be accurate. But that's when the best practices have been used.
And is confidence necessarily related to accuracy?
Not in all circumstances. And as I said, when best practices are used, that confidence statement of the witness can be very useful at the time of the identification.
During your review of this case, did you find any factors that may have inflated the victim's confidence in their selection of Michael Keetley?
Well, I don't have there's, as I understand it, no audio of the actual identification procedure or no video of the actual identification procedure. And so it's impossible for me to know whether there's anything specifically that did influence his competence.
Your Honor, if I could have a second. If a witness, kind of along the lines of what we talked about a little bit with Jose Rodriguez, if a eyewitness was shown a text that had a picture of the perpetrator on it, or heard discussions that a certain individual had been the person that committed this crime, would that be a factor that would affect that individual's reliability and accuracy of their eyewitness selection?
Yes, there could be another form of the contamination that I talked about earlier.
I don't have any other questions at this time.
Cross-examination? Yes, thank you.
Good afternoon.
You've addressed a number of variables as you described them concerning eyewitness identification, and indicated that they could have affected reliability in any given identification in this case. Is that correct?
That's correct.
However, you don't know for a fact whether any of these variables actually impacted or affected any of the witness identifications in these cases, do you?
That's correct.
Thank you. Nothing further.
Nothing.
May this witness be excused by the defense
Yes.
and by the state? Thank you, ma'am. You may step down. You may be excused as the witness at this time.
Oh, you know what I need? Before I release the jury, I need the attorneys to approach. With the attorneys about the schedule for tomorrow, I'm going to let you go today, and then I'm going to bring you back at 12:30 tomorrow. So go ahead and eat before you come in your lunch, because we're going to go from 12:30, and we expect to finish tomorrow the presentation of evidence. We're not going to do the closing arguments, though. We're going to bring you back Friday morning for closing arguments, and then get you out to start deliberating Friday afternoon. And I will let you know that under those circumstances where we're doing closings first thing Friday morning, I will order pizza again, so you can eat while you're deliberating, or if there's a break, if we take a short break in the middle of the closings, it'll be like we did last time, like a 45-minute break, and we'll have pizza for you. Come back, finish the closings, and then go back and start deliberating. But you will be deliberating this case early Friday afternoon, and we are going to finish tomorrow. But we only have a couple of witnesses, and one of them can't be here till the afternoon. So that's why we're bringing you back at 12:30 tomorrow. So sleep in tomorrow, relax, have some coffee, grab some lunch before you come, and then we'll start at 12:30. Please do not discuss the case amongst yourselves with anyone else. Please do not do any research related to the case, and avoid all reports of the case outside of the courtroom. We'll see you at 12:30 tomorrow. All rise for the jury. Jury has exited. Everyone may be seated. I was thinking about telling you to come in at 12 and we can do jury instructions, but if we're going to be done by roughly 3 o'clock, we'll have plenty of time in the afternoon, and we can do the jury instructions after I send them home for the day. Tomorrow. You wanted to do them tomorrow, right?
That's our preference. How long do you think Hopper is?
Well, last time he was, if I looked at it, it was about 2.5 hours last time. So.
Okay, well, even if we start him at 1, because you said the witness, we're going to start at 12:30, and that witness is no more than 30 minutes.
No, that witness is less than that.
Right. So if we start Halpern, if he gets here at 1, or if he gets here a few minutes before 1, we may be ready for him, put him on. But that's 2:30, 3:30. Still, if we finish at 4 o'clock, that's plenty of time to do instructions tomorrow afternoon.
Yeah, Miss Burgess, who is our 12:30 witness, has to be at work by 2. So that all works out good. If we're good on the downbeat at 12:30, she'll be in it, and she'll be off the stand easily.
I just want to make sure, you all had indicated that you were going to send some special instructions to them. I just want to make sure, though, that even if we have to stay late tomorrow, that we finish the instructions, because I don't want that to take up any time Friday morning. When we get in here Friday morning, I want to read. I'll probably have them come in at 8:30 Friday morning. I'll read instructions. We'll start closings hopefully before 9 o'clock. And I know you said you wanted 2 hours, and they said roughly the same. So we'll probably have a break in between the rebuttal argument, maybe have pizza for them, let them eat, take a 30, 45-minute break, and still get them out deliberating before 2 o'clock on Friday.
Can I ask, I know different courts do different things. Are you going to read them the law before closing arguments, or?
I am. I do it both ways, but the initial instructions had that, so I thought you all had agreed upon that. But I prefer that anyway, so I am going to read the substantive instructions.
So you'll read everything?
Yeah, except for the final, there's one page that we read afterwards.
The submission to the case to the jury, that's what goes on. Okay.
Yep.
What about, I know usually this isn't done, but what if we instructed the jury Thursday afternoon? What if we went over the jury instructions tomorrow morning and we instructed them Thursday afternoon and went straight into closings Friday morning?
By doing it Friday morning, it's fresh in their mind. I think that's.
Yeah, I don't think it is going to be that long. The proposed instructions I saw, they weren't that thick, so I think the reading of the instructions will be 20 minutes. I'll read fast. So let's do that. I agree that it's.
Well, we're not asking that, Judge. It's fine.
No. Oh yeah. No, I'm sorry. I won't read too fast. But I kind of agree that with that break, it's probably better to just do it all at the same time. It's a good thought, though. Not a bad idea. Well, we'll see. But be ready to do the instructions to argue the instructions, do the charging conference tomorrow when we're done with Halpern after you rest. And I mean, there's always still the possibility of a state rebuttal, and there's also the possibility I have to go over with Mr. Keetley whether he's going to testify or not. I presume that that decision has not absolutely been made at this time. I recognize he didn't testify the first time, but who knows, things could change. So, Mr. Keetley, I want you to be prepared tomorrow after Dr. Halpern. I'm going to have a colloquy with you, just like I did the last time, asking you about, it's your decision, and I do recommend that you discuss your decision with your attorneys, but at the end of the day, it's your decision. So I'll be asking you if you've made a decision and what that decision is regarding testifying tomorrow.
Okay.
All right. Anything else?
Speaking of argument.
Oh, wait. What? Oh, yeah, JOA.
We have a couple of housekeeping issues. Jennifer Dysart's testimony is going to be entered as Court Exhibit 6.
Excellent.
So get that to the clerk.
Excellent. Thank you.
We also had, during Omar Bailon's testimony, mixed up with the exhibits. We ended up with two Exhibit 7E. One of them was already admitted. So the 7E that was previously admitted during prior testimony is the photograph of all of the guys together with their hands. That one was previously admitted as 7E. The other one that was referred to as 7E is the ocean mist street signs on the Facebook page. That one was referred to as 7E. It should be 7F.
F?
F, as in Frank.
All right. State, any issues with that?
We don't have any issues with that now that there's a clarification. It's fine.
Okay. All right. Mr. Grant, are you ready to argue on your preserved motion for judgment of acquittal?
I am not.
No?
But Ms. Villamil is.
Oh, Ms. Villamil. All right.
I get to talk for once in the trial.
You do. I'm all ears.
Your Honor, defense is moving for judgment of acquittal at this time. The state has charged him in the indictment with 2 counts of premeditated first-degree murder for Juan and Sergio Guitron as the listed victims, 4 counts of attempted first-degree murder on Mr. Guevara, Beltran, Cantu, and Galan. For all of those charges, the state has to prove premeditation and the state has to prove identity, and they have failed to do that in this case. As to the premeditation, there's no indication that Mr. Keetley knew any of these victims. It was made very clear that he had never once asked about Magic or Spider or any of these individuals by name when he was out in the community asking questions. He had the internet with Miss Connie Bell. She testified extensively about the things on his computer. There were no hits indicating anything regarding these potential victims, Mr. Guevara, Mr. Galan, and the others. And even as to the individual creeper, there wasn't much there. There were no hits. So there was nothing on the computer that really indicated any kind of premeditation in this case. As to the identity, we had 2 victims, I believe, who made the in-court identification of Mr. Keetley as the alleged shooter, but all of them were under the influence at the time of the shooting. All of them indicated this was a very quick-moving situation. They did not really get a good look at him. And all of their individual descriptions did not match Mr. Keetley, specifically the height and the weight and the hair. They all indicated an individual who weighed much heavier than Mr. Keetley did at the time and much taller than Mr. Keetley at the time. Additionally, Mr. Keetley had a disability. All of the state's witnesses, including the individuals who did not want to admit it, all eventually admitted on cross that Mr. Keetley had a hand injury. Something was off with his hand. They maybe didn't go into detail about how much something was off with his hand, but everybody admitted there was something off there. And they all admitted that he had an issue walking as well as a result of his injuries from his shooting in January of 2010. None of the victims of this shooting, Mr. Guevara, Mr. Rodriguez, who's not a charged victim, and Mr. Beltran, none of them indicated that the person who walked up on them that night had any kind of limp or any kind of disability with hand. They all indicated that the shooter used both hands. They were very clear it's a pump-action shotgun. They said repeatedly the person was racking the gun, and that requires 2 hands to do. It's also important to note that the identification of the photo pack was questionable. Mr. Guevara was in the hospital on morphine, had been previously hallucinating at the time that Detective Lugo came and showed him the photo pack. The SOPs were violated, as we pointed out in the administration of the photo pack. It was not a double blind. Detective Lugo knew who the suspect was, and there was also some question about whether Mr. Guevara had seen the text message circulating in the community and whether he was mentally competent to do that because of the morphine and the injuries that he sustained at the time he was given this photo pack to look at. Mr. Guevara, when he came in court, gave a very different description of what he gave back in 2010. Like everyone else, he said that the individual who shot at him was heavy. It was in the 280-pound range, and Mr. Guevara said that he weighed about 220 at the time, so he would know what a 280-pound person is compared to himself. But interestingly, at the time of the shooting, the person who shot him apparently had brownish orangish hair and rosy red cheeks. But when he came in court, suddenly he has gray hair. He wanted to identify Mr. Keetley in court. It was not the same consistent description of the person who allegedly shot at him back in 2010.
But isn't that a credibility question for the jury?
Your Honor, I think it is credibility, but I think it's also important for the court to make that, to be aware of that, because when you're evaluating the evidence, you have to evaluate everything that's been presented. And just because one person can make a description and match that person in court, you have to still understand that that is not the actual description that was given previously and that the testimony has changed. And in that case, it's very significant that he is pointing out somebody who has aged 13 years and looks very different than he did in 2010.
Let me ask you on the premeditation issue, what does the case law say if one plans to go to a specific place, say a theater, and go in the theater to shoot people and goes in, theater 3 and shoots people they've never met before, they don't know, but they plan to go there and shoot people. Is that not a first-degree premeditation murder case?
Premeditation can be established through transferred intent. There is case law on that, Supreme Court cases. However, just because it was the victims in this case that he didn't know doesn't necessarily mean he didn't have premeditated, that there wasn't premeditated intent. But again, the state didn't prove premeditation at all. Even if we are to argue, or the state's to argue, that he was premeditated intent to go after Creeper, Mr. Bailon, if we're going to assume that this is what happened, there's still no evidence that he was going to go after Bailon and shoot and kill him. Again, the computer, no searches there, maybe a couple, I think they said for Creeper 2 or 3. No evidence that he was trying to obtain any weapons, no evidence that he was trying to figure out how to dispose of a body, anything that was actually incriminating. So there's nothing on the search. All he is guilty of is asking around in the community, trying to solve a crime that was committed against him. He was shot and left for dead in his own car, in his truck. And I don't think I got to Daniel Beltran, but he's the other victim. He couldn't make an identification. Then you add in this text message that's floating around the community the morning of the shooting. It's contamination. And all of the victims, the ones that were able to give IDs, only gave those IDs after they had seen these text messages.
But again, is it contamination something that should be argued to the jury regarding the credibility of that eyewitness's identification?
I would argue it goes to the totality of the state's case. The standard for a judgment of acquittal is obviously that they have to meet the low burden, all inferences in their favor, that they have made a prima facie case. Prior to 2020, the standard for a circumstantial evidence case was different, and obviously now that has changed, but in this case, it is a circumstantial evidence
They used to
case.
have to disprove all reasonable hypotheses of innocence, but they no longer have to do that, correct?
That's what they used to do. And had this case been tried previously to 2020, that would have been the standard that would apply to this case, and I think that they would have been unable to make that standard back then because this is a circumstantial evidence case. And the evidence, the hypothesis of innocence is that Mr. Keetley was not there. And there hasn't been any direct evidence that Mr. Keetley was actually at this crime scene. There was no direct evidence that Mr. Keetley premeditated to go out there to kill anyone. So we would be asking for a judgment of acquittal because neither one of the elements of premeditation or identity have been met in this case.
All right. Thank you, Ms. Villamil. Let me hear from the state.
Judge, in the light most favorable to the state, there is direct and circumstantial evidence. We have two witnesses who have identified this defendant, Mr. Navarro, who said he is 1,000%, 2,000% certain. He identified him here in court. You had Jose Rodriguez also identify the defendant. We don't just have direct evidence. There is overwhelming circumstantial evidence in this case, namely the ballistics that tie the shell casings, the spent shell casings, and the projectiles from the crime scene to a gun that was fired on the Keetley property. There was one spent shell casing near a burn pit. There were projectiles that were taken from the van where Mr. Keetley and others went target practicing. As far as premeditation is concerned, there is overwhelming evidence of premeditation. David Beckwith talked about how he met with the defendant, who was upset with the police investigation. Numerous other witnesses testified in this court that he was, in fact, not happy with law enforcement investigation, that he did his own investigation, that he was looking for creeper. Carrie Bowes, who is a friend of the defendant or married to a friend of the defendant, who went to visit him twice in the hospital, said in that conversation that she had with him on November 26th that he wanted revenge, that he wanted the people who did what shot him, that he wanted them to feel that exact pain that he had felt. We're talking about victims that were shot in the leg, a victim that was shot in the hand, a victim that was shot in the chest. So there is ample evidence of premeditation that he was looking for creeper. The victims and live victims that survived this, and Mr. Rodriguez, all were very consistent that the only thing that person said and wanted was looking for creeper. And so the defendant himself, in an interview with law enforcement, denied that very interview with Detective Lugo said that he did not do that. So there is the state does not have to prove motive, so not only do we have direct and circumstantial evidence, but we have overwhelming evidence of motive. Certainly it is enough to go to the jury, Judge.
All right, anything else from the defense?
Your Honor, just in regards to the casings, as Ms. Doherty said, other people were shooting. Those casings could come from others. So that's all I have to add, Your Honor.
All right, and again, I think there's a lot of things here that I think are factual questions and issues for the jury to determine. As to the premeditation, the fact of the matter is that somebody did it. Somebody walked up on that porch and addressed the victims and had them lay. The testimony, whether it was him or somebody else, I think there's enough to find premeditation, since premeditation can be formed in an instant. And the victims all testify the surviving victims testify that they were confronted, they were told to lie on their face on the porch before they were shot. So I think there's enough, and I think there's case law that supports that premeditation could have been formed by whoever it was who did that. I think there's other issues and other defenses that the defense is going to raise, and a lot of those depend upon factual findings that the jury should make. So I'm going to deny the motion for judgment of acquittal at this time.
And Your Honor, we also just renew all prior motions.
Same rule in all prior motions and objections.
Yes, I was going to make sure we did that at the bench.
You did, but it's okay to do it again too. It's been preserved, and obviously my position is same ruling on all prior motions and objections. All right, so what did we say, 12:30 tomorrow? Well, I'll be here a little bit early, come in and check on you all and make sure we're ready to go. The witnesses are here, and sounds like it'll be a relatively short day, but that's fine.
Yes, sir.
We've been at this for 4 weeks now.
Ms. Khan.
Certainly not a short trial.
Now, Ms. Khan.
May have a short day, but not a short trial.
Short day in a long trial. Ms. Khan has been in regular contact with Dr. David Halpern, so we expect that he'll be ready to go right at 1 o'clock. Ms. Kolev and I have been in regular conversation with our other witness, so she will be here so that she can testify and get to work.
All right.
There is one other matter. I do want to address the juror.
Yes.
Sometime tomorrow, if we can address also the juror who was personally treated and had surgery by Dr. Halpern.
Yes. Did you want to do it now or tomorrow?
Judge, I will do it tomorrow. That way I can provide research to defense counsel
Okay.
and to your honor as well.
So I have no objection to that. Just trying to figure out what time you would like us here, because really the only concern I have at this point is making sure we're ready to start the witness testimony at 12:30 so Burgess can get to work and Halpern can get up.
We won't do it before.
Okay.
Because I don't know exactly what's going to be argued, what the case law is, and say how I'm going to handle it. But it might include the interview or the questioning of the juror after the doctor has testified before I can make a decision. I don't know. I'm just thinking out loud. I'm not suggesting.
Judge, if anything, it would just be to remove her for an alternate. There's case law that talks about if I did not use all my peremptories.
That's what I.
information
Yeah.
That,
Yeah.
you know,
That's,
if I had known at the time of, and the question was asked, so it's case law along that line. So I'm not asking for her to be removed. We still are in the position where we have alternates available to us. So I'm not.
well, she would be removed. She's on the jury. She would have to be removed, and we'd substitute. We'd bring in an alternate. But that's what I'm not recalling clearly. But I am not surprised. Is there case law that says if you learn something afterwards that you would have exercised and you still had peremptories, that you're able to do that now. That's the case law that I'm interested in.
Within the discretion of the judge.
Right.
Judge.
Right, and it's one of those, same lines as when you're required to provide a race-neutral reason. I think it's the same analysis. So bring me the case law tomorrow. We won't argue it before. We'll argue it after.
Okay.
But
So I just.
and I agree with you that eliminates the need to interview the juror.
Judge, and you did interview her, and she did say that she could, she believed she still could be fair and impartial, so I was fine with that questioning. So it's just one of those things that it
Your
was asked,
position
and she-
is that had you known that during the selection process, you would have used one of your remaining peremptory challenges to excuse her.
Yes, because she said that that she had a surgery from him up here. Like when we first asked, either she didn't recognize the name or whatever. But like I don't remember, it was day one. The trial had already.
Just like if the defense learned now that one of the jurors, after seeing Lugo testify, said, "Oh, I remember him when he was a patrol deputy. He changed the tire on my car," and they want to say, "Well, we want to strike him, even though he says that he can be fair, but we had a peremptory and we'd like to strike him." Same analysis I would use for their request.
Correct, Judge.
And from our perspective, we can argue that up tomorrow, as we mentioned, and depending on where the court goes, I'll have some suggestions based on that. I'm just making sure we're going to do all of that at or around 3:30 or 4 when the jury's released.
Yes.
After Halpern, we are expected to be ready at 12:30.
That's right.
Doing anything with you beforehand.
That's correct.
Okay. And I'll make sure, I'll talk with the state, we for the record, we have gone a few days without issues, right? So if there are issues, we'll hopefully reach out to you before.
And I appreciate that, and that shows the level of expertise and professionalism on both sides. And I greatly appreciate that. Mostly you?
I think it's my influence, if I must say, Your Honor.
I can't get any credit no matter what I do.
I think it's my hand.
I think it's the large spot back here that people admire.
Can I just request if there's any changes to the jury instructions that I get a new copy sent to the judge?
Yeah, if there's anything you agree on between now and then, because I do want you all to talk in the meantime.
Yes, I think there's almost near the agreement on the instructions. I think we've got a couple we want to pitch
Right.
the way that may need to.
Right. Well, if they agree to those, whatever you're pitching, let us know and send it to us. All right. Have a great evening. I'll see you. I was going to say in the morning, but I'll see you in the afternoon.
You don't leave, I want to get a picture of your neighbor.
Oh, okay.